A president, a gag order, a proposed mistrial, daily press conferences, 10 contempt of court verdicts, 2 gag order hearings, 24-hour news coverage, political punditry, and 34 findings of guilt. This video isn't about any of that. The jury found Trump guilty without knowing any of these sideshows. This video is about the evidence and arguments presented in the courtroom that yielded 34 guilty counts. This is the first of 3 sections. Here, I'll lay out the facts of the case from the prosecution's perspective, the defense's evidence and arguments will be in part 2, and the prosecution's rebuttal arguments will be in part 3. The prosecution claim that Michael Cohen, at the direction of Donald Trump, bought the story of adult performer Stormy Daniels related to a 2006 affair she had with Trump. Employees at the Trump organization, at Trump's direction and with Trump's input, then created the plan to pay Cohen back. The execution of this plan created 11 invoices, 12 vouchers, and 11 checks, which had false information, which make up the 34 charges in this case. Other details about past hush money payments, including a conspiracy between Trump, his lawyer Michael Cohen, and National Enquirer editor David Pecker, as well as the testimony of Stormy Daniels, are also included. They were introduced by the prosecution to flesh out the story and prove aspects of the case that were required for Trump's guilt. But before we get to the evidence and arguments, we need to know the law. The specific jury instructions came as a result of a hearing between the prosecution and the defense, which Judge Merchan took into account when writing the final instructions. To find Trump guilty, the prosecution must prove beyond a reasonable doubt, number 1, that on or about February 14th, 2017, in the county of New York and elsewhere, the defendant personally or by acting in concert with another person or persons made or caused a false entry in the business records of an enterprise kept or maintained by the Trump Organization. And number 2, that the defendant did so with intent to defraud that included an intent to commit another crime or aid or conceal the commission thereof. To prove point 1, the prosecution must show beyond a reasonable doubt all of the following: the documents or business records, that they were created on the specific date listed in the jury instructions, an aspect of the record is factually false, and Trump acting with others in the Trump Organization caused the records to be created. The prosecution must also prove beyond a reasonable doubt that Trump had an intent to defraud and that Trump had an intent to conceal the commission of another crime. There are 34 counts in this case, for the 34 documents involved in Trump repaying Cohen. For every count, every single one of these points needs to be proven to the jury beyond a reasonable doubt. If even one juror finds that one of these factors wasn't proven, there cannot be a guilty verdict on that count. So I would encourage you to look past anything that happened outside of the courtroom, ignore any preconceived biases to either side, and carefully weigh the evidence and arguments to determine whether, in your view, Donald Trump is guilty or not guilty. So join me on this first part of the journey, where we analyse the documents and testimony that the prosecution presented to find the 45th President of the United States guilty of 34 felonies. In this circumstance, building a guilty case is like building a house. There is the foundation which is necessary before one can construct any walls. In our court analogy, the foundation are the elements of guilt which are not disputed between the prosecution and defense. Both sides largely agree that the 34 business documents exist, were created on the specific dates indicated on the documents, and that they were created by the Trump Organization. Each of the 4 walls of the building then relate to an element of the case which is in dispute between the 2 sides. They are that the entries in the documents are false, that Trump caused the documents to be created, that Trump had an intent to defraud, and that Trump had the intent to conceal the commission of another crime when he caused them to be created. The prosecution will present the case for each wall and argue that all of the walls are strong and that they can definitely hold the roof of the building. And the defense will argue that the walls are weak and that we can't know beyond a reasonable doubt if they can hold the roof. The jury then needs to inspect the evidence and arguments, and if they find that the walls are of sufficient strength, they will put the roof on and complete the guilty case. However, if they find that even one of the walls wouldn't be able to hold the roof, they can't complete the house, finding Trump not guilty. Starting with the foundation of the building, this one is pretty simple. There are 34 counts, each of which represent a business record that was used by the Trump Organization to repay Michael Cohen. Deborah Tarasoff, who is the accounts payable supervisor at the Trump Organization, attested to their authenticity. There are 11 invoices sent by Michael Cohen, which are then stamped by Deborah Tarasoff. Tarasoff then created 12 vouchers in the MDS system. The MDS system is an internal database that the Trump Organization uses to pay invoices. Ms. Tarasoff created the vouchers for each invoice, with 2 being created for the February invoice, since that month's invoice comprised the January and the February payments. Finally, 11 checks and stubs were created by Ms. Tarasoff, and the first 2 were signed by Donald Trump Jr. and Eric Trump, with the rest being signed by Donald Trump himself. All these documents also have dates showing when they were created and were kept as business records of the Trump Organization. The prosecution had to prove all of these aspects beyond a reasonable doubt, but it wasn't disputed much in the trial. Now, before we move on to the walls of the house, we first need to talk about the garden. A garden isn't a required part of a house, and the garden plays no part in holding up the roof. Thus, when inspecting individual walls, the jury shouldn't be taking the quality of the garden into account at all. But the garden does influence the character of the home. In this case, the garden is the Stormy Daniels affair. Even if Stormy Daniels was completely lying and made everything up, that doesn't make the payments from Cohen to her legal. And even if everything is completely true and Trump sent goons to threaten her, that doesn't prove his guilt with respect to falsifying documents. But who even is Stormy Daniels? Stormy Daniels has been working in the adult entertainment business since she was 17. She has never worked for either party in the case, but has been involved in several civil lawsuits against Trump. She is appearing in court pursuant to a subpoena issued by the prosecution. But first, a quick explanation. During this video, I will sometimes play voice clips in these colored rectangles. These are directly quoting from the official trial transcript. I use them when the precise wording of the witness could be relevant, as they relate to evidence that is in dispute between the defense and the prosecution. Other times, I will just say that something happened. This is for when the information is not in dispute. So for example, I will play Daniels' quoted testimony about her interactions with Trump, since the sides have a different interpretation of those events, but I'm just going to say that Cohen was Trump's personal attorney, since everyone agrees to that. So, what is Miss Daniels' story?
So, Wicked sponsors one of the holes on the golf course, and we had a table in the gift room where celebrities would come through, get a gift bag, check out the products, pose for photos. You would stay at your hole that had the company's logo, and you would give them water, towels, take a photo. And then later the next day, or whatever, the evening, they would go to the gift rooms. Everybody came through. There were so many photos with the girls, with all the celebrities that came through that day. He did remember us from the golf course. He talked to all of the girls. He remembered me specifically, that I was the smart one. He asked for a DVD. He specifically asked for the one that I had directed. We talked very briefly. Then I saw him talking to his security. And then he said that he came back and asked said that Mr. Trump would like to know if I would like to have dinner with him.
Did you end up going to his hotel, Mr. Trump's hotel, to have dinner with him?
I did. So I arrived and I went upstairs. The door was actually open, it was cracked open, and his bodyguard, Keith, was standing right outside the double doors to his room. He said, "Hi, nice evening, you look nice," 1 or 2 sentences of pleasantries, and said, "Go on in." The door was already open, so I walked on in. He said, "Mr. Trump is there waiting for you." And I called his name, I said hello, and he came from one of the main areas of the hotel suite. You know, when you say hotel room, people often think of a hotel room that we are used to, and when you walk in, there is a bed, a dresser, and that's the connotation that people have in their head when you say a hotel room. This hotel room was 3 times the size of my apartment, and I was sitting directly across from him in the main area, the living room bar area behind me. And he said, "You know, it was a bit early. Would you mind just talking for a bit and get to know each other, and then we can go down or we can stay up or whatever?" I said, "Yes, absolutely." So I took a seat and we started talking. Yeah, I mean, it's getting to know you, it's pleasantries. He was very interested in a lot of the business aspects of it, which I thought was very cool. He showed me a few pictures of things and I said, "Oh, what about your wife?" I actually said, "She is very beautiful. What about your wife?" He said, "Oh, don't worry about that. We don't even sleep in the same room." He would ask me questions and then not let me finish the answer. He kept cutting me off, and it was almost like he wanted to one-up me, which was just really hilarious when you think about it. He just wanted to talk about himself. At this point, I pretty much had enough of his arrogance and cutting me off and still not getting my dinner. So I decided someone should take him on. So I said, "Are you always this rude, arrogant, and pompous? You don't even know how to have a conversion," and I was pretty nasty. I snapped, and he seemed to be taken aback. And I said, "Someone should spank you with that. That's the only interest I have in that magazine, otherwise I am leaving." I don't think he thought I would do it, so he rolled it up and gave me the look that he dared me to do it. So I took it from him and said, "Turn around," and I swatted him.
Where do you swat him?
Right on the butt.
Right after that, did you continue to sit down and talk?
Yes, and he was much more polite.
Did you have a discussion with him about The Apprentice?
He got really quiet and he was thinking, and he told me he had an idea that I should go on his television show. I don't remember the TV show, The Apprentice. I assume it's Celebrity Apprentice. I don't know, The Apprentice. And I said, there is no way NBC would ever let an adult actress on television. And I said, even you don't have that much power. And he said that he did. He said, "You remind me of my daughter because she is smart and blonde and beautiful, and people underestimate her as well. And I am a good writer and director." And he said, "This is your chance to have somebody see that part of you." I was like, "Well, but I'm not a business person. I don't have that kind of education. There is no way I could win." He said, "You don't have to win. You just have to show who you are." I said, "What if I lose on the first episode?" And then he said, "What if I tell you what the challenges are?"
Approximately how long in total were you talking in the suite with Mr. Trump?
Well, close to 2 hours. It was a long time.
Now, at that point, meaning after all of that discussion that you just described, did you sense any red flags or reason that you were concerned about being there?
No.
At some point, did you need to use the restroom?
I had been there for quite a while. I drank a couple of bottles of water, which is all we were drinking. It was water, and I needed to use the ladies' room. So I asked if that was possible, so I was instructed to go through the living room and to the bedroom and to help myself to the facilities. When I came out of the bathroom, I expected to exit, go around the bed, and back out to where we had been sitting and talking and hopefully say, "Okay, time to go. I have been here for a long time." That was actually when I realized how long I had been there. And when I opened the bathroom door to come out, Mr. Trump had come into the bedroom and was on the bed, basically between myself and the exit.
What was he wearing at the time?
His boxer shorts and t-shirt. At first I was just startled, like jump scare. I wasn't expecting someone to be there, especially minus a lot of clothing. That's when I had that moment where I felt the room spin in slow motion. I felt the blood basically leave my hands and my feet, and almost like if you stand up too fast and everything kind of spinned, that happened too. Then I just thought, oh my God, what did I misread to get here? Because the intention was pretty clear. Somebody stripped down in their underwear and posing on the bed like waiting for you. And I went to step around. I laughed nervously and, tried to make a joke out of it and step around and leave, even though I was moving like I was in a funhouse slow motion. I thought to myself, great, I put myself in this bad situation. Like, what did I do? How did I misread everything? He stood up between me and the door, not in a threatening manner. He didn't come at me. He didn't rush at me. He didn't put his hands on me and nothing like that. I said, "I gotta go." He said, "I thought we were getting somewhere. We were talking, and I thought you were serious about what you wanted. You ever want to get out of that trailer park, basically?" I was offended because I never lived in a trailer park. I just think I blacked out. I was not drugged. I never insinuated that I was on drugs. I was not drunk. I never said anything of that sort. I just don't remember.
Did you feel threatened by him?
No, not physically, although I did note there was a bodyguard right outside the door. There was an imbalance of power for sure. He was bigger and blocking the way. But I was not threatened verbally or physically. The next thing I know, I was on the bed, somehow on the opposite side of the bed from where we had been standing. I had my clothes and shoes off. I believe my bra, however, was still on. We were in the missionary position.
Was he wearing a condom?
No.
Did you say anything about it?
No.
Why not?
I didn't say anything at all.
And tell us what you recall about getting dressed.
Sitting on end of the bed, noticing that it was completely dark outside now, and that it was really hard to get my shoes on. My hands were shaking so hard. He said, "We should get together again. We were fantastic together. I want to get you on the show."
Did he express any concern at that point about his wife finding out?
No. I told very few people that we had actually had sex because I felt ashamed that I didn't stop it, that I didn't say no. The next day I met him, this time at my hotel, nightclub, restaurant, bar downstairs. They did a silent auction. They had cocktails, however, whatever. I met him at one of the nightclubs there. He was sitting at a booth in a nightclub. Then he said he did come back to me. "Hey, everything about our idea, I think it's good. I got to get back home and figure out how to get you on the show."
Did Mr. Trump call you after that encounter in July of 2006 in Tahoe?
He would call on average once a week, sometimes 2 or 3 times a week, sometimes not at all for 3 weeks. He would always call. He always definitely loaded the call with an update or a non-update if he didn't have one for The Apprentice, and always talked about when we could get together again. Did I miss him? He always called me Honey Bunch. My publicist thought it was good to continue my conversations with him about the television show. He would call from a New York number, or from Keith's number and or Rona's number, I guess, and said he was going to be in L.A. He had the final information almost all sorted out for the show. Would I meet him again for dinner at his bungalow, the Beverly Hills Hotel?
And tell us a little bit about what you discussed with him in the bungalow.
He kept trying to make sexual advances, putting his hand on my leg, scooting closer, giving me compliments.
What was your response?
I told him I was on my period.
Was there more discussion about The Apprentice?
Yes, but a lot less than I thought there would be. No real update.
And about how long did you stay?
2 hours tops. More than an hour, less than 2.
Did you have an experience in about June of 2011 with an encounter in a parking lot in Las Vegas?
My daughter and I went to postpartum, like a workout for a mommy and me workout thing, and I was approached by a man in the parking lot in Las Vegas, in the center of a shopping center that the class was located in. And I thought he was the father or the husband of one of the other women in the class. And he approached me and said that he threatened me not to continue to tell my story.
Did you tell the police at the time?
No.
Why not?
Because he told me not to say anything at all. And I was scared. And I didn't want more of the story coming out.
Now, let me direct your attention to about October of 2011. Did you become aware at around that time that an article had come out and been posted online about your encounter with Mr. Trump on a site called thedirty.com?
Yes, Gina called and told me.
Were you concerned about it being up at the time?
Yes, because I had been threatened, and I didn't want the person who threatened me and my baby thinking I had done it.
Now, I'd like to direct your attention now to 2015. Were you aware at some point that Mr. Trump announced that he was running for president?
Yes.
Did you have a conversation with a friend of yours who is an attorney?
Yes, he helped me set up a press conference that we didn't end up doing.
Did your conversation with him and what happened to you in the parking lot in Las Vegas in 2011 guide your decision about telling your story as a way to make sure that it was documented and out there?
Yes.
Did you decide to let Gina try to sell your story to some news outlets?
Yes.
Did you have any intention of approaching either Mr. Trump or Michael Cohen, his attorney, to have them pay for your story?
No, my motivation wasn't money. It's to get the story out.
Did there come a time that you learned in approximately October of 2016 that Donald Trump and Michael Cohen were interested in buying the rights to your account?
Yes. They were interested in paying for the story, which was the best thing that could happen because then my husband wouldn't find out, but there was still a documentation of a money exchange and a paperwork exchange so that I would be safe and the story wouldn't come out.
Were you told by Ms. Rodriguez how much in total would be paid from Donald Trump and Michael Cohen to purchase the rights to your story?
$130,000.
And how did you feel about that $130,000 at the time?
Didn't care. I didn't care about the amount. It was just to get it done.
Did you express dissatisfaction and want this signed and done by October 14th?
Absolutely.
Why was that?
Because I was afraid that if it wasn't done before the nomination and things, that I wouldn't be safe, or that he would never pay, and there wouldn't be a trail to keep me safe.
What did you understand at this point about what the general terms were of this agreement?
So that in exchange for the sum of $130,000, that I could not tell my story, that he also couldn't tell the story. We could not contact each other or each other's families or representatives. We had to pretend like we didn't know each other at all. If I spoke, it was like $1 million every time I said something.
Obviously, that was just some of Daniels' story related to meeting Donald Trump and signing the NDA. There were some serious limitations the judge put on what the prosecution was allowed to ask her, in particular around the sexual act itself. The defense chose to elicit some more testimony from her about that.
And according to you, when you saw him sitting on the bed, you became faint, the room started to spin, and the blood left your hands and feet, yes?
Yes, it was shock, surprise.
And that made you feel like you were going to faint?
Absolutely. If I came out of the bathroom and saw an older man in his underwear that I wasn't expecting seeing there, yeah.
This was not the first time in your life someone had made a pass at you, was it?
No. But it was the first time that they had a bodyguard standing outside the door and they were in their underwear.
Okay.
And they were twice my age and bigger than me. But he did stand up, and he was between me and the door, and Keith was outside the door, and then I don't remember. And then I remember we were kissing, and he was on top of me.
But you blacked out, right?
I got lightheaded. I never blacked out. I didn't, hit the floor. Everything spun and went black. But no, I was not given any drugs. I did not take any drugs. And I don't even believe there was alcohol in the room.
Now, obviously, that was just the prosecution side of what happened, and there'll be more about how the defense worked to undermine that story in the next part. It's worth keeping in mind that in this case, technically, the accuracy of all that Daniels said doesn't particularly matter, but it can be used by the jury when weighing other evidence, and Daniels' credibility is relevant for other parts of her testimony which go towards actually proving relevant parts of Trump's guilt. So, now that's all out of the way, let's return to our humble abode, and we are actually going to start with the fourth wall first. For this wall, the prosecution needs to prove that Trump had the intent to conceal another crime when causing the creation of the 34 documents. That crime is a violation of Section 17-152 of New York election law, which provides that any two or more persons who conspire to promote or prevent the election of any person to a public office by unlawful means in which conspiracy is acted upon by one or more parties thereto shall be guilty of conspiracy to promote or prevent an election. Knowledge of a conspiracy does not by itself make the defendant a co-conspirator. The defendant must intend that conduct be performed that would promote or prevent the election of a person to public office by unlawful means. We will get to the illegal means of the conspiracy later, but first, let's learn about the players in the conspiracy that the prosecution alleges. Michael Cohen worked as Trump's personal attorney at the Trump Organization from 2007 to 2016, and was thereafter the personal attorney to the president until 2018. He pleaded guilty to 5 counts of tax evasion, 1 count of false statements to a financial institution, 1 count of violating the FECA with a corporate contribution to a campaign, and 1 count of excessive campaign contribution. All those charges are related to his conduct in the events of this case. He also pleaded guilty to lying to the Senate and House Intelligence Committees related to his work on Trump Tower Moscow. He served a little over a year in prison for all of these, and did not receive a decrease in his sentence for his testimony in this case. He is testifying due to a subpoena issued by the prosecution. The other man at the core of the conspiracy is David Pecker. He worked as the chairman, president, and CRO of AMI, which is the owner of the National Enquirer, some other tabloids, and many fitness magazines. He has never worked for Donald Trump or the Trump Organization, but they have been friends for many years and worked informally regarding news stories about Trump. He is testifying pursuant to a subpoena issued by the prosecution. The premise of the conspiracy is that Trump, Pecker, and Cohen had a meeting in 2015, just after Trump announced his presidential campaign. At that meeting, Pecker agreed to use the National Enquirer to write positive stories about Trump and report any negative stories he hears to Michael Cohen. Those stories could then be caught and killed, meaning that the rights to the stories can be bought and then not published. This would ensure that details stay private, since the source could not give them to another news organization since they'd already sold the rights. There are 7 major parts of this conspiracy, which were central to this case. There was a meeting between Trump, Cohen, and Pecker, where Pecker agreed to use his position at AMI to help the Trump campaign. Multiple positive stories were written about Trump, and several negative stories were written about Trump's opponents. Pecker did a catch and kill on a story about Trump fathering an illegitimate child. Pecker did another catch and kill on a story about a year-long relationship between Trump and former Playboy model Karen McDougal. There was a plan to sell the Karen McDougal story from Pecker to Trump, along with a folder of other negative stories about Trump. Finally, Michael Cohen did a catch and kill on the Stormy Daniels story, which was just described. But obviously, the prosecution can't just say that it happened, they have to prove it using evidence. So, we're going to go through each of these claims and show the most important evidence that was presented to prove it beyond a reasonable doubt. The first part is related to the meeting. Here's how Pecker describes it.
And who was present for that meeting?
Donald Trump, Michael Cohen, and Hope Hicks. At that meeting, Donald Trump and Michael, they asked me what can I do and what my magazines could do to help the campaign. So thinking about it, as I did previously, I said what I would do is I would run or publish positive stories about Mr. Trump, and I would publish negative stories about his opponents. And I said that I would also be the eyes and ears of I said I would be your eyes and ears, because I know that the Trump organization had a very small staff. And then I said that anything that I hear in the marketplace, if I hear anything negative about yourself, or if I hear anything about women selling stories, I would notify Michael Cohen, as I did over the last several years. I would notify Michael Cohen, and then he would be able to have them kill in another magazine, or have them not be published, or somebody would have to purchase them.
Michael Cohen describes what was discussed at the meeting in a very similar way.
What was discussed was the power of the National Enquirer in terms of being located at the cash register of so many supermarkets and bodegas, that if we can place positive stories about Mr. Trump, that would be beneficial. That if we could place negative stories about some of the other candidates, that would also be beneficial.
Was there anything else that Mr. Pecker said he could also do for Mr. Trump's candidacy?
Yeah.
What in substance did he say?
What he said was that he could keep an eye out for anything negative about Mr. Trump, and that he would be able to help us to know in advance what was coming out and try to stop it from coming out.
And who did he say he would get in touch with if he was able to identify those types of stories?
The answer was me, Mr. Trump also. Knowing my relationship with David, the two of you should work together, and anything negative that comes, you let Michael know and we'll handle it.
As you may have noticed, Pecker said that Hope Hicks was also at that meeting. He later added that Hope Hicks was in and out of the meeting. Here is her recollection of the events.
You testified earlier that as part of your job, you were sometimes in and out of Mr. Trump's office when he was having other meetings. Is that right?
Yes.
Were you ever in and out of his office when Mr. Pecker was meeting with Mr. Trump in Trump Tower?
I don't have a recollection of that, but it's certainly possible.
You have seen him in Trump Tower before, Mr. Pecker?
Yes?
So, while this does not directly corroborate the meeting or the conspiracy, it is some evidence from a source who is not a member of the conspiracy. But who even is Hope Hicks? Hope Hicks started working for the Trump Organization in 2014 as a director of communications and worked for the Trump campaign before following him into the White House, where she was the communications director and later the counselor to the president. She now does consulting work and hasn't communicated with Trump since 2022. She was subpoenaed by the prosecution and is paying for her own lawyer. Moving on to the next part of the conspiracy, which is the positive stories about Trump and the negative stories about Trump's opponents, which were published in the National Enquirer as a result of this scheme. There were many positive stories, including that he was endorsed by JFK's secret son and Obama's half-brother. On the negative stories side, we have stories panning Ben Carson's surgery ability, labeling him Ben the Butcher. Ted Cruz was accused of having 5 mistresses and his father being involved in the assassination of President Kennedy. Marco Rubio was accused of having an illegitimate child and a cocaine addiction. David Pecker would describe Cohen's direct involvement in creating these negative stories.
My conversations with Michael Cohen would call me and he would say, we would like for you to run a negative article on, let's say for argument's sake, on Ted Cruz. Then he would send me, he being Michael Cohen, would send me information about Ted Cruz, or about Ben Carson, or about Marco Rubio. That was the basis of our story, and then we would embellish it from there.
Cohen would then show the stories to Trump.
Did AMI sometimes send over the covers of some of these stories to you before they ran them?
Yes.
And what did you do with that material when they sent it over to you?
Immediately showed it to Mr. Trump.
And for what purpose did you show it to Mr. Trump?
So that he knew that David was loyal, was on board, was doing everything that he said he was going to do in that August meeting, and was actually doing it.
And do you recall from time to time when you showed Mr. Trump some of those stories what in general, his reactions were?
That's fantastic. That's unbelievable.
Hope Hicks would describe the calls she overheard of Trump praising the negative stories.
One of them was, I think, shortly after the National Enquirer published a piece about Ben Carson, and I just overheard a conversation between Mr. Trump and Mr. Pecker, who was on speakerphone, and Mr. Trump was congratulating him on the great reporting.
What was the article about Dr. Carson about?
Medical malpractice.
Did you hear Mr. Trump say anything in particular on this phone call with Mr. Pecker?
I think he was just congratulating David on a great investigative piece. You know, sometimes he would say things like, "This is Pulitzer-worthy." I kind of recall vaguely that is something that he said.
Was that the only time you heard or were present for a phone call between Mr. Trump and Mr. Pecker in this time period?
It's the most vivid recollection of everything I have. I think a similar conversation took place sometime a few months later, also just praising some of the reporting that the National Enquirer was doing. I think maybe around the time there was a story about Ted Cruz.
The next section of evidence related to the conspiracy is Pecker and AMI buying the story of Trump Tower doorman Dino Sajuden. Sajuden claimed that Trump fathered an illegitimate child with a maid that worked at Trump's penthouse. Both the prosecution and the defense agree that the story is factually false. However, the catch and kill of the story by AMI goes towards the conspiracy to influence the election. Before we get into the evidence, we have to bring up the last key player in the conspiracy. Dylan Howard does not get his own profile in the key witnesses section, since he didn't testify due to not being able to travel from Australia because of poor health. He was the editor-in-chief at the National Enquirer, and Pecker immediately informed him about the plan right after the meeting in Trump Tower. Pecker told Howard to vet any stories he hears about Trump and then bring them to him, and he would then inform Michael Cohen. For the Sajuden story, it was Howard who heard about it and brought it to Pecker, who then pushed it forward to Cohen. AMI then purchased the story. Even after Pecker had it confirmed that the story was false, he bought it anyway, since it was very damaging for Trump's campaign.
I asked Dylan to negotiate a price, to negotiate a number, a price to buy the story and take it off the market.
Did you discuss the purchase of the story with Michael Cohen?
I called Michael Cohen up. I called Michael Cohen, and I said that we have to go forward with the story. And he said, "How much?" I said, "Dylan negotiated a price of $30,000. So he said, "Who's going to pay for it?" So I said, "I'll pay for it. This can be a very big story. I believe it's important that it should be removed from the market. So we'll acquire the story." He thanked me, and he said that the boss would be very pleased.
Who did you understand the boss to be?
The boss would be Donald Trump.
Pecker also believes that Cohen informed Trump about the story.
Because there was a second conversation after that, where he called and said that the story is absolutely not true. He said that Mr. Trump would take a DNA test, that he is German-Irish, and this woman is Hispanic, and it's absolutely impossible.
Cohen also corroborates Trump's involvement.
Well, I went to him immediately to advise him that there was a story because it was a negative story for him and to get his direction on what he wanted me to do. He told me to make sure that this story doesn't get out. You handle it.
And as the matter progressed and you got updates from Dylan Howard or David Pecker, did you update Mr. Trump about the matter?
Immediately.
Cohen even personally made alterations to the final agreement to better protect Trump.
I thought that there needed to be a clause in there, a significant penalty for $1 million per violation of any of the terms of the agreement to ensure that the doorman knew not to go ahead and to talk about this matter. What I found was that the agreement had what I considered to be an end date to, and so rather I said, why not just, let's make this in perpetuity.
Finally, we have the contract itself, including the amendment agreement, which shows the changes Cohen suggested. The next catch and kill story was related to Karen McDougal. Howard informed Pecker about a Playboy model in California who claimed to have had a year-long relationship with Trump. He then called Cohen and they agreed to vet the story. Cohen now spoke to Trump about the story.
I told him about what I had just learned. I asked him if he knew who Karen McDougal was, if he knows anything about the story. His response to me was, she's really beautiful. Said, okay, but there is a story that's right now being shopped.
What did he ask you in general to do?
Make sure it doesn't get released.
Howard had a meeting with McDougal and her attorney Keith Davidson and found that while she didn't have any corroborating evidence, he thought the story was true. Later, Trump called Pecker directly.
When I got on the phone, Mr. Trump said to me, I spoke to Michael. Karen is a nice girl. Is it true that a Mexican group is looking to buy her story for $8 million? I said, I absolutely don't believe that there is a Mexican group out there to buy a story for $8 million. And then he said, what do you think I should do? I said, I think you should buy the story and take it off the market. He said to me clearly that he doesn't buy stories because it always gets out. And he said to me that Michael Cohen would be calling me. He was going to speak to Michael, and he would be calling me back.
Cohen was in Trump's office during that call and largely corroborated its contents.
He asked him how things were going with the matter, and David said, we have this under control, and we will take care of this.
Was there a discussion on that call about how much might cost to buy this story and who might pay for it?
Yes, ma'am.
Just in substance, what was that conversation?
So David had stated that it's going to cost them $150,000 to control the story, to which Mr. Trump replied, no problem, I will take care of it.
Was there an understanding about who would initially purchase that story?
Yes.
And who was discussed on that call that would purchase that story?
AMI was going to lay out the funds, and as Mr. Trump had stated to David, I will take care of it.
And what did you understand that to mean?
He was going to pay it back.
Cohen then later called Pecker.
He said, you should go ahead and buy this story. So I said to him, I'm going to have Dylan Howard negotiate the terms. And then I said, who's going to pay for it? So he said to me, don't worry, I'm your friend. The boss will take care of it.
Who did you understand the boss to be a reference to?
Donald Trump.
So, while there was some disagreement about who said what in which call, they both agree that Donald Trump was the ultimate beneficiary of the deal. Stormy Daniels' lawyer, Keith Davidson, had a similar understanding.
I called him and let him know, as a professional courtesy, that the deal involving his client had closed. And I told him, as it stated to you and Dylan Howard, that this deal wouldn't have happened without Dylan.
Now, you said that you called Michael Cohen as a professional courtesy because the deal involving his client closed. What client is that?
Donald Trump.
Davidson is a new player in this case. He has his own legal practice where he represents celebrities in civil matters. He has never worked for Donald Trump or the Trump Organization. He is testifying pursuant to a subpoena from the prosecution. Due to testifying at the New York grand jury, he has complete immunity for any involvement in this case. It was understood by both parties that this deal was essentially a catch and kill. They agreed that McDougal's story would not be published. That was one of the key reasons why McDougal chose the AMI deal over the alternatives. Davidson had a theory at the time as to why AMI did this.
Did you have an understanding as to why AMI would be purchasing a story that they didn't intend to print?
I think there were two. I think one explanation that was given was that they were trying to build Karen into a brand and didn't want to diminish her reputation. And the second was more of an unspoken understanding that there was a close affiliation between David Pecker and Donald Trump, and that AMI would not run this story or any story related to Karen and Donald Trump, as it would tend to hurt Donald Trump.
When you say hurt Donald Trump, you mean hurt Donald Trump's campaign?
Yes.
This seems to also point towards outside parties being aware of the conspiracy between Pecker, Cohen, and Trump. The final piece of evidence related to this deal is the agreement itself. In exchange for $150,000, AMI would have the rights to the story, McDougal would appear on 2 AMI fitness covers, and she would pen 25 articles. The next part of the conspiracy involves the plans for Trump to buy McDougal's life rights, alongside a number of other negative stories which were being stored in a drawer in the AMI offices. Pecker needed to be paid back for the McDougal deal promptly, since the $150,000 expenditure would be discovered during quarter-end reporting if not reimbursed. There was also some urgency on Trump's end surrounding the other stories in Pecker's possession.
So David had expressed to me that obviously the relationship with Mr. Trump goes back many, many years, and there is a file drawer, or a locked drawer as he described it, where files that relate to Mr. Trump existed. And at that point in time, David was being considered for the position of CEO at Time Inc. Time magazine. And one of the concerns that I had, that I expressed to Mr. Trump, was if he goes, there is a series of papers there that relate to you. Well, I didn't know what those stories were, and nobody was discussing that with me, but that they would be open for use.
Meaning that other people might get their hands on them?
Yes, because we didn't know who the potential CEO or replacement would be.
Pecker backs up that the files were important to Cohen and that he wanted to purchase them.
In September, Michael Cohen said that Mr. Trump wants to acquire the lifetime rights of the Karen McDougal story, and I should assign the contract over to him. When I say over to Michael Cohen and I would be reimbursed, the company would be reimbursed. And he also added on that Mr. Trump wanted all of the content that the National Enquirer had or developed and retained on Mr. Trump. I told Michael that, these are old files and boxes that are in Florida. The company has been moved to New York City, and there is nothing in those boxes but old news articles, magazine articles, old files. He insisted that he wanted those boxes, and he wanted the content.
To convince Pecker that he would indeed get paid back, Cohen recorded a meeting between himself and Trump on his phone.
I need to open up a company for the transfer of all of that info regarding our friend David, so that I'm going to do that right away. I've actually come up and I've spoken to Alan Weisselberg about how to set the whole thing up with
So what are we going to pay?
Funding, yes. And it's all the stuff, because you never know where that company, you never know where he's going to be. Correct. So I'm all over that. And I spoke to Alan about it when it comes time for the financing, which will be.
Listen, what financing?
We'll have to pay you. So
don't pay with cash.
No. I got no. Hey, Bill, how are you?
So Cohen and Pecker work on creating an agreement to exchange the stories for funds. The final agreement can be seen here. Cohen set up the company Resolution Consultants to create apparent separation from Trump. The final deal turned out to be $125,000, since AMI valued the McDougal magazine covers and articles at $25,000. However, the deal ended up falling through. After talking to his lawyer, Pecker called off the deal. He goes on to describe a conversation with Cohen, informing him the deal was cancelled.
I called Michael Cohen and I said to him that the assignment deal is off. I am not going forward. It is a bad idea, and I want you to rip up the agreement. He was very, very angry, very upset, screaming basically at me. Michael Cohen said, "The boss is going to be very angry at you." I said, "I am sorry, I am not going forward. The deal is off." And he said, "I can't believe it. I am a lawyer. I am your friend. I don't understand why you are so concerned." I said, "I am very concerned, and I am not going forward, period." And I said, "Are you going to rip it up or not?" And he said, "I will take care of it."
Cohen had a different recollection of why the deal fell through.
David Pecker contacted me and stated that it was no longer necessary to have Mr. Trump pay the $125,000. I asked him why. Satisfied, because now I would report to Mr. Trump that he wouldn't have to pay that amount of money, which would make him happy. And the reason was because the Karen McDougal front cover on Men's Health magazine had sold more copies than they had not only anticipated, I think that they had ever. The way David expressed it to me, that they had ever sold and they had made a lot of money on that. and that it was no longer necessary because he didn't need to bury the $125,000. He also then had a second cover to use McDougal on, as well as the 24 additional articles that she was. That was going to be penned with her name on it. So he felt that it was, even for the $150,000, it was an excellent business deal.
And what was Mr. Trump's reaction?
It was great. He doesn't have to pay $125,000 or $150,000.
While these differences do matter in terms of determining the credibility of the statements, and obviously it looks much better for Trump if the agreement fell through because AMI made so much money that it wasn't necessary to get paid back, as opposed to Pecker's lawyers encouraging him to cancel the agreement. Either way, the transfer agreement could go towards conduct to promote the conspiracy between Cohen, Pecker, and Trump. The final part of the conspiracy that I'm going to include as part of this wall is the purchase of the Stormy Daniels story by Michael Cohen. The reason that this is part of the conspiracy involving David Pecker and AMI is due to their participation in finding and negotiating the deal, even if they weren't the source of the funds this time. It was Dylan Howard who was offered the story.
And I received an urgent call from Dylan Howard. And Dylan said that he received a call from his two best sources, Keith Davidson, who we know is the attorney for Karen McDougal, and this other source, Gina Rodriguez, who is an agent for those type of celebrities. He said that she, being Stormy Daniels, is trying to sell a story that she had a sexual relationship with Donald Trump, and Dylan can acquire the story for $120,000 from Keith Davidson if we make the decision right now.
After Pecker decides not to buy this story, Howard instead brings it to Cohen.
So the Access Hollywood tape dropped. Gina and Dylan came to terms at $120,000. Dylan backed out, which left that deal up in the air. AMI did not want to complete the deal, or would not complete the deal, and Dylan asked Gina to call Cohen and close the deal with him.
Cohen essentially accepts the deal, but at Trump's command, he starts stalling to try and make it past the election without paying the hush money. After the election, he would cancel the deal. Davidson and Daniels see through this and void the agreement and prepare to give an interview to the Daily Mail. Howard and Pecker manage to get the deal back on and have a call with Cohen.
Well, it was all about, again, the resolution of the non-disclosure agreement.
And what, if anything, was Dylan Howard telling you on that phone call?
How to get this thing done. She's going to the Daily Mail. This could be catastrophic to the campaign. This will further isolate women from the candidate.
And did you make a request at that time of Mr. Pecker on that call?
If he would be kind enough to make the payment.
Why did you ask him to make the payment at that point?
To see if he would do it, considering he's been doing it for Mr. Trump before. I figured, why not ask?
What did he say?
Not a chance.
Pecker finally gives some advice to Cohen.
I said, Michael, my suggestion to you, you should buy the story. You should take it off the market because if you don't, and it gets out, I believe the boss will be very angry with you.
As it turns out, Cohen did heed that advice and bought the story shortly thereafter. That concludes the main bits of evidence that are presented by the prosecution to prove that there was a conspiracy. To finish with the narrative of events, we still need to go over how Cohen bought the story and how Trump repaid him. To do that, we're going to head to wall number 1. For this wall, the prosecution needs to prove beyond a reasonable doubt that the entries in the business records are false. They posit that the payments were in large part a repayment for a $130,000 purchase of the Stormy Daniels story. Michael Cohen says that he bought the story at the direction of Donald Trump with an expectation of getting paid back. He took $130,000 out of a home equity line of credit so his wife wouldn't find out, and funded the shell company, Essential Consultants, who then paid Daniels. There was a side letter agreement held only by Cohen which identified the parties. This way, even if the contract were to leak, Trump would not be connected to it. Later that year, Trump won the election, becoming the 45th president of the United States. It was a transition period as Trump was moving away from the Trump Organization to his new home in Washington, D.C. Cohen was already perturbed due to not being paid back for the Daniels deal and was furious when his end-of-year bonus was cut. Cohen was particularly offended by this due to all the work he had done to get Trump elected. In particular, he had spent $130,000 of his own money to protect Trump. Even Trump's closest ally and Trump Organization CFO, Alan Weisselberg, had refused to go that far. So Cohen went to Weisselberg and informed him of how annoyed he was. Weisselberg assured Cohen that he would be made whole, and later, Trump called Cohen from Florida to tell him he would be taken care of. The repayment of Cohen, in particular the 34 financial documents, are at the core of this case. The prosecution needs to prove that these are false, and the key way they do this is by identifying the false entries in each document. For the 11 invoices, they all say they are for services rendered. The 12 vouchers all mention a retainer agreement and say that they are legal expenses, and 11 check stubs say they are related to a retainer agreement. All of these are false, since they were a reimbursement to Michael Cohen. If the prosecution can prove beyond a reasonable doubt that it was a reimbursement, then this wall is solid. The key documents that prove that these are reimbursements are Exhibits 35 and 36. People's 35 is a print-off of the bank statement that shows the $130,000 payment to Daniels. Cohen printed it off as proof to show Weisselberg. In a meeting between Cohen and Weisselberg, writing was added to the bottom of the page. On the bottom right, Cohen added $50,000 to the $130,000, summing the total to $180,000. The $50,000 was another reimbursement to Cohen after he'd paid consulting company Red Finch for some work they had done for Trump. On the left-hand side, Weisselberg takes the $180,000 and grosses it up, meaning he doubles it for taxes. He then adds $60,000, which was to make up for the cut bonus. Total repayment to Cohen thus amounted to $420,000. Cohen says that he went with Weisselberg to Trump's office, who insisted that the payback be split into monthly payments and take place over the course of a year, whereupon Weisselberg wrote that down at the bottom of the page. Weisselberg then went to Trump Organization Senior Vice President Controller Jeffrey McConney. McConney took notes on his Trump Organization notepad during the meeting, which is now Exhibit 36. McConney incorrectly wrote down $50,000 for the bonus instead of $60,000, but Weisselberg corrected this when it came to the final sum. The note also includes the $180,000 reimbursement, and this one explicitly says ×2 for taxes. These documents at face value clearly show that Cohen was not getting paid for legal services, but was being reimbursed for payments he had made for Donald Trump, one of which was the hush money payment. But there is also other evidence that appeared at the trial that this was a reimbursement. Multiple parties testified that they thought it was a reimbursement. Obviously, Cohen said it was.
Well, what was it actually?
Reimbursement of my money. It was a repayment of the Stormy Daniels payment, as well as, again, you had the bonus and then the Red Finch money.
McConney also mentioned that Weisselberg thought it was a repayment.
Alan said we had to get some money to Michael. Reimburse Michael.
Before the meeting that yielded the handwritten documents, Cohen also told Davidson that he hadn't been paid back yet, indicating he expected to get paid back.
And then he made reference to, he said, I never even got paid, he said. That fucking guy is not even paying me the $130,000 back.
Cohen also mentioned to Pecker that he hadn't been paid back yet.
Michael said to me that he wasn't reimbursed for the monies owed to him on the Stormy Daniels payment.
And finally, on multiple occasions, Trump has admitted that it was a reimbursement. Firstly, Donald Trump admitted to reimbursing Cohen through a legal filing which was part of a lawsuit with Stormy Daniels. The document itself didn't make it into the trial, but there was this exchange on the redirect with Stormy Daniels after the defense opened the door on cross-examination.
And do you recall that his attorneys, Mr. Trump's attorney in court papers filed in June of 2018, confirmed that Donald Trump in 2017 had reimbursed Michael Cohen's company, Essential Consultants, for the $130,000 that was paid to you?
Yes, I saw that.
So that was confirmed in Mr. Trump lawyers' submitted court papers, correct?
Correct.
The second admission is on a government ethics form. Since Trump was president, he had to fill out certain public financial forms. On page 45 of this document, there is a note which states that, while it is not required reporting, in the interest of transparency, Trump is reporting an expense incurred by Michael Cohen, which was reimbursed in 2017. It also states that the reimbursement amount is between $100,000 and $250,000. Finally, in May 2018, Trump tweeted, stating the monthly retainer Cohen received had nothing to do with the campaign and that it was reimbursement for the NDA with Stormy Daniels. He finishes the tweet thread by saying that money from the campaign or campaign contributions played no role in the transaction. So it seems that Trump, while denying using campaign funds, seems to have admitted that Cohen was paid a reimbursement. That concludes the most important evidence presented by the prosecution that the payment was a reimbursement and thus the entries in the business documents are false. If this evidence proves that beyond a reasonable doubt, then this wall is strong and that component of the case is proven. Next up, we're going to check out wall number 2. For this wall, the prosecution needs to prove beyond a reasonable doubt that Donald Trump acted in concert with others to create false business documents. First, there was some testimony at the trial that stated that Trump knew about or was directly involved in repaying Cohen. Obviously, we have Cohen's testimony. Here, he describes what happened at the meeting with Weisselberg, where the repayment amount was determined.
What did you do, and where did the two of you go at that time?
We went to Mr. Trump's office in order to speak to him about this.
And did he show this document to Mr. Trump?
Yes.
Did Mr. Weisselberg state in front of Mr. Trump that you were going to receive $420,000 over the course of 12 months?
Yes.
And what, if anything, did Mr. Trump say at that time?
He approved it, and he also said, this is going to be one heck of a ride in D.C.
Keith Davidson thought Trump was involved since he was the beneficiary of the agreements.
And did you know when you were dealing with Michael Cohen that you were dealing with Donald Trump?
Yes, I never thought otherwise.
He also felt like Cohen couldn't spend any of Trump's money without Trump's approval.
And then he said, well, goddammit, what do you expect me to do? My guy is in 5 fucking states today, or 3 or 4 or 5 different states today. There is nothing I can do. I'm doing everything I can.
When he said that his guy was in a certain number of states, who did you understand his guy to be making reference to?
Donald Trump.
And what was the relevance based on your conversation with Michael Cohen about what was the relevance of the fact that Mr. Trump was in 3 or 4 or 5 different states?
To me, it was similar. It's a situation I run into all the time. It was similar to like someone who doesn't have the purse strings. It's like an attorney has to go call an insurance adjuster. Like that. Michael Cohen didn't have the authority to actually spend money despite the fact there has been so many excuses and funding deadlines that have already been missed.
We saw earlier on Wall 4 how both Pecker and Cohen testified that Trump was involved in the conspiracy to catch and kill stories. We also heard some of his involvement on audio tape. Since he was involved in the conspiracy, it makes it more likely that he was involved in the reimbursement and cover-up. Alan Weisselberg is pretty strongly connected to the repayment, given that it's in his handwriting that the repayment amount is calculated on Exhibit 35. Rebecca Minocchio, who is a bookkeeper at the Trump Organization, said that during the time frame when the repayment scheme was created, while Trump was in the office, he met with Weisselberg every day.
And as Mr. Weisselberg's assistant for 8 years, did you become familiar with the people Mr. Weisselberg interacted with at the Trump Organization?
Yes.
When Mr. Trump was in the office, how often would Mr. Weisselberg interact with Mr. Trump?
Every day.
Given that Weisselberg knew about the repayment, he probably would have informed Trump. Rebecca Minocchio is a junior bookkeeper at the Trump Organization. She has been working there for 11 years and she is testifying pursuant to a subpoena from the prosecution. There is also copious amounts of evidence that Trump would keep track of and be involved in everything the Trump Organization did. He writes that in his books. For example, from this chapter, called Pay Attention to Detail, it says, if you don't know every aspect of what you're doing, down to the paper clips, you're setting yourself up for some unwelcome surprises. Pecker supported this and describes Trump as a micromanager.
I would describe Mr. Trump as very knowledgeable. I would describe him as very detail-oriented. I would describe him as almost as a micromanager from what I saw, that he looked at all of the aspects of whatever the issue was.
If you believe that Trump had knowledge and involvement in everything that went on in the Trump organization, that would go directly towards Trump being involved in the Cohen repayment. The other large pillar that would point towards Trump being involved is the fact that he signed the checks. The Trump organization was set up so that any expense over $10,000 could only be approved by Trump himself. It is another piece of evidence that Trump was a micromanager, and even after he became president, he didn't change this procedure and still wanted to personally sign the checks from his account. When the last 9 checks to Cohen were issued from the DJT account, Trump had to sign them at the White House. If Trump is a careful person who pays attention to details and he signs the checks without questioning anything, that indicates that he knows why Cohen is getting paid and approves it. We have already established that Pecker thinks Trump is detail-orientated, but Madeleine Westerhout backs it up too.
In general, is he the type of person who would pay attention to details?
In my experience, yes.
In your experience, did he typically read things before signing them?
Yes.
Westerhout worked as Trump's executive assistant at the White House. She is testifying pursuant to a subpoena issued by the prosecution, and her lawyer is taking the case pro bono. Deborah Tarasoff was the person who prepared the 9 checks for Trump to sign. Here is her check preparation method.
Once you cut a check, what would you do with it?
I would cut the check, put it together with the backup, and bring it over to Rona, so she would bring it in to Mr. Trump to sign.
You said put it together with the backup?
The invoice.
Was there ever more than an invoice, or was it usually just an invoice?
Basically, it's just an invoice.
And how would you put the check together with the invoice?
Just put the check on top of the invoice, staple it, and bring it over.
Deborah Tarasoff is an accounts payable supervisor who has been working at the Trump organization for 24 years. She was subpoenaed by the prosecution, and her attorneys are being paid for by the Trump organization. Rebecca Minocchio backed this check preparation method up and stated that this procedure was uniform across the Trump organization.
I put checks with their backup together and gave them to Mr. Weisselberg to sign.
And what do you mean by backup?
The invoice.
Did every check that you put together for Mr. Weisselberg to sign have to have an invoice attached?
Yes.
Do you know if the process was consistent kind of across the Trump organization for paying expenses?
Yeah.
Finally, Pecker testified that he saw checks prepared this way.
I had a meeting with Mr. Trump in his office, and when I was there, his assistant Rona brought in a batch of invoices and checks to sign. And I observed Mr. Trump, he asked me, while he was reviewing the accounts payable packages, we were talking at the same time, and I noticed that he reviewed the invoice and looked at the check, and then he was signing them.
Tarasoff also testified to what Trump would do if he didn't like the check or invoice.
What if you cut a check from the DJT account? Did Mr. Trump have to sign the check because Mr. Weisselberg approved it?
No. If he didn't want to sign it, he didn't sign it.
Did you ever see situations where he didn't sign checks?
Yes.
What would happen in those situations?
He would write void on it and send it back.
How do you know he would write void on it?
It was signed in a Sharpie in black. That is what he usually uses.
Madeleine Westerhout also describes what would happen if Trump needed clarification on an issue related to the checks.
Do you remember if Mr. Trump ever had questions about the checks?
I think I remember maybe a couple times him having a question about a check and then calling Alan Weisselberg or somebody else in the Trump organization to ask for clarification.
Rebecca Minocchio agreed with this point.
And what did she tell you would happen if a check was missing?
If it was missing, either it got lost or he had questions about it and he had to speak to someone.
And when you say he, you are saying?
Mr. Trump.
He might have a question on a check that was found?
Yes.
That is why he didn't send it back up?
Yes.
And if he had questions, what would happen? Would you question him?
No, that's as far as I go.
Would you just wait to get further instructions on what to do, if anything, with the checks?
Yes.
Since Trump signed the 9 checks and didn't call anyone to clarify, he must have known about the repayment scheme, which yielded the 34 false documents. This wall contains the prosecution's evidence that Trump knew about the reimbursement plot. If these facts lead to the conclusion beyond a reasonable doubt that he knew and that he was involved, then this wall is solid. Next up, we get wall number 3. which is where the prosecution needs to prove Trump's intent. The prosecution does not need to prove that there was any premeditation. They just need to show that when Trump caused the false business records to be created, he had the intent of creating false business records. We are instructed to take into account the things that Trump said and did, the results of his actions, and what would have been the probable outcome of his conduct. Lots of previous evidence will also go into proving this wall. We have Cohen's testimony that Trump was involved in creating the repayment scheme and Trump's signing of the checks. We also have the fact that false business records were created and that the plan to repay Cohen while disguising the payments would have to create false business documents. But we also have some other supporting evidence, starting with why Trump instructed Cohen to buy the Daniels story and why he was desperate to cover it up. According to Davidson, Stormy Daniels had actually tried to sell her story back in April, but nobody was particularly interested. However, later, the Access Hollywood tape was released. The judge ruled that hearing the tape in Trump's own voice was unnecessarily prejudicial, so I won't play it here. But the content is basically that Trump claimed to kiss women he had just met and grab them by the genitals. He said that they wouldn't stop him because he was a star. This was a big problem for the campaign. Madeleine Westerhout, who was working at the Republican National Committee at the time, described some of the fallout.
At the time, I recall it rattled the RNC leadership.
Did the RNC leadership consider replacing Mr. Trump as a candidate?
It's my recollection that there were conversations about how to, if it was needed, how it would be possible to replace him as the candidate if it came to that.
The release of the tape was clearly something Trump would have wanted to prevent. At the meeting back in 2015 between Cohen, Pecker and Trump, they mentioned that there would probably be women coming forward and that it would be negative for the campaign. Thus, in large part, the conspiracy from the start was about suppressing those stories. Trump also tweeted around this time that he lost a large amount of female voters due to his comments on the tape. In another tweet, he claims that nothing actually happened. This gives an insight into Trump's strategy to defend against the tape. He claimed there was locker room talk and words, not actions.
I've never said I'm a perfect person, nor pretended to be someone that I'm not. I've said and done things I regret, and the words released today on this more than a decade-old video are one of them. Anyone who knows me knows these words don't reflect who I am. I said it, I was wrong, and I apologize. I've traveled the country talking about change for America, but my travels have also changed me. I've spent time with grieving mothers who've lost their children, laid off workers whose jobs have gone to other countries, and people from all walks of life who just want a better future. I have gotten to know the great people of our country, and I've been humbled by the faith they placed in me. I pledge to be a better man tomorrow and will never, ever let you down. Let's be honest, we're living in the real world. This is nothing more than a distraction from the important issues we're facing today. We're losing our jobs, we're less safe than we were 8 years ago, and Washington is totally broken. Hillary Clinton and her kind have run our country into the ground. I've said some foolish things, but there's a big difference between the words and actions of other people. Bill Clinton has actually abused women, and Hillary has bullied, attacked, shamed, and intimidated his victims. We will discuss this more in the coming days. See you at the debate on Sunday.
So it was really important for the campaign that no new women's stories came out before the election, since that would undermine the words not actions defense. In fact, Cohen and Pecker took down a past article that alluded to the Daniels affair. It was published in 2011 on thedirty.com, which had since come under the ownership of AMI. So the prosecution posit that this was the key motive that led to the purchase of the Daniels story and the subsequent reimbursement to Cohen. Cohen could then not get paid back normally, as that might expose the story and the whole catch and kill scheme. Another key factor that shows Trump's intent is the fact that Cohen was paid back double. This was to hide the reason for the reimbursement. Pecker described Trump as a very frugal person.
I thought that his approach to money, he was very cautious and very frugal.
and Jeffrey McConney describes a lesson Trump taught him about haggling and being prudent with money.
Early on, I think I was employed for about a year. President Trump was on the phone. I walked into his office, dropped a report on his desk, turned around, and he said, "Jeff, hold on a minute." Sorry. He said to who he was talking to, the person on the phone, "Hold on a minute," and turned around and said, "Jeff, you're fired," and started talking to the person on the phone again. I stood there until he got off the phone call, and he said, "You're not fired, but my cash balances went down from last week." He said, "I know you negotiated this." He said, "Now focus on my bills." It was a teaching moment. Just because somebody is asking for money, negotiate with them, talk to them. Just don't do it mindlessly. Think before you do it.
Jeffrey McConney is now retired. He worked for the Trump Organization for 39 years, and during the time of the reimbursement was the Senior Vice President Controller. He was called by the prosecution, and his lawyers are being paid for by the Trump Organization. Trump also backs up his diligence with funds in his books. Some extracts from Trump's book, Think Like a Billionaire, were included as evidence. He writes, "Every dollar counts in business, and for that matter, every dime. Penny pinching? You bet. I'm all for it." He also writes an anecdote about how Spy Magazine sent checks ranging from 50 cents to $5 to millionaires around the country. He got a check for 50 cents and he cashed it. He also includes the interaction that McConney just described. So then, why would Trump reimburse Cohen double the amount? If he labelled the payment as a reimbursement, Cohen would not have to pay taxes on it, and Trump would not have to double it up. Trump clearly put a high value on disguising the payment. This value is particularly high if we believe the evidence that was just displayed, showing that Trump is usually a penny pincher and doesn't overpay people. Once again, these factors, along with the circumstances of the situation and Trump's actions, which are described on other parts of the House, all contribute towards proving Trump's intent. If we believe that it was proved beyond a reasonable doubt, then Wall 3 is solid. Finally, we get to the last part, which brings us back to Wall 4. We've already gone over the evidence that Trump was involved in a conspiracy to influence the election, but the prosecution needs to prove that the conspiracy involved illegal means. There are 3 different criminal means that are posited. They have all already been brought up, and some of the evidence connecting it to Trump has been shown earlier on this wall. The first is illegal campaign donations. Under the Federal Election Campaign Act, corporations cannot donate directly to campaigns, and individuals can donate a maximum of $2,700. The term donation includes a purchase made for a candidate if the purchase would not have occurred but for the candidate running for office. The prosecution have 2 corporate contributions from AMI, that being the $30,000 purchase of the Sajuden story and the $150,000 purchase of the McDougal story. They also have 1 private contribution exceeding $2,700. That is the purchase of the Stormy Daniels story by Michael Cohen. If the prosecution has proven that any of these occurred as part of the large conspiracy between Pecker, Trump and Cohen, and they would not have occurred but for Trump running for president, then Wall 4 is proven. The second illegal means that the prosecution put forward was the violation of tax law. It is illegal to submit false tax returns, even if in the end it doesn't result in any underpayment of tax. There are 2 false tax forms, one related to the payment of Cohen from the revocable trust account, and one from the DJT account. They list it as non-employee compensation and have Cohen pay tax on it. These are false tax returns, as the payments are reimbursements for the Daniels purchase, and Cohen should not pay any tax on that. The final legal means is the falsification of business records. This is similar to the main charges in the case, but they are for different documents than the core 34. These documents all came as a result of different parts of the conspiracy. These were the shell companies that Cohen set up to first buy the McDougal story from AMI and then eventually purchase the Daniels NDA. These documents are false, as it states that the companies were set up as consulting companies, which is untrue since they are meant to be used to disguise Trump buying women's stories. Cohen actually explicitly said that he called them consulting companies because he thought the bank would reject them if their true purpose was listed. The next ones are the documents associated with Cohen's wire transfer from Essential Consultants to Keith Davidson. Of note is that Cohen lists the purpose of the wire as being for a retainer. This is not true, as it was a payment for an NDA. Next up, we have the invoice that AMI sent from Investor Advisory Services to Resolution Consultants LLC for Trump to reimburse AMI for buying the McDougal story. Once again, the purpose of the transfer is false, as it states that it is an agreed upon flat fee for advisory services when it was in fact to buy the rights to the McDougal story and other stories about Trump. The final false business documents are actually some we saw very recently. They are the 1099 tax forms issued by the Trump Organization to Michael Cohen. Apparently, they are not just a violation of tax law, they are also false business documents. This makes sense, since them being false is what causes them to be a violation of tax law in the first place. If it is proven beyond a reasonable doubt that any one of these documents is false, was created as part of the conspiracy to influence the election, and that Trump had an intent to create it, then this section is solid. So those are the three illegal means that the prosecution put forward. Now how this works is that each juror just needs to find that one of these was proven beyond a reasonable doubt. Jurors can also disagree on which one was proven, as long as they all agree that at least one was proven. So for example, one juror could determine that the election donations was proven, but the other ones were in some way insufficient, and a second juror could come along and say that the violation of tax law was strong, but the other ones were just totally made up in some way. Both jurors would determine that this was solid, even though they disagree on the underlying facts of what was shown. So, that concludes part 1 of the series. That's the basic evidence put forward by the prosecution to find Trump guilty. What do you think? Do you think the prosecution have a solid case, or are they missing some key aspects for you? Whatever your opinion, remember that you've only heard from one side so far, and in the next part of the series, the defense gets to strike back. And that's right now. Let's look at the prosecution's arguments. Let's once again start with the garden of the house. The garden doesn't hold up the roof and shouldn't matter directly for finding guilt or innocence, but it does colour lots of the rest of the story. Stormy Daniels testified that she was, at best, coerced into having an affair with Trump in 2006, and years later, Trump sent a goon after her to threaten her and to keep her quiet. Daniels then signed an NDA with Trump's fixer, Michael Cohen, to protect her and her daughter. The defense, on the other hand, say that she is lying about having relations with Trump as part of an extortion scheme to get money. Either way, it doesn't make the conduct that Trump is accused of legal, which is why the evidence is in the garden and not on the walls of the building. But it certainly looks better for Trump if he is an innocent victim of extortion, as opposed to paying an adult entertainer hush money to cover up him cheating on his wife. So, it's clearly in the defense's best interest to make Stormy Daniels seem as non-credible and generally just as bad as possible. Here is how they did that. The defense pointed to some inconsistencies in Daniels' narrative. Daniels has told her story multiple times, the first time in 2011 and multiple times since then. Each time, some things are different. In 2011, she said that Trump directly asked her to dinner. She later said it was Trump's bodyguard Keith Schiller who asked for Trump. She also said in 2011 that she had dinner, but now claims that they never ate. She used to say that she walked to Trump's hotel, but at trial she says she walked halfway and then took a car for the other half. It's worth noting that the two hotels are about a block apart. There was also an inconsistency on where Trump was when she first entered the room. The prosecution claims that she agreed to the NDA for her own safety after she was threatened by a man sent by Trump. On cross-examination, the defense grilled Daniels on this encounter and brought up some more inconsistencies.
And you claim that in 2011, after you sold your story to In Touch, you were approached by a man in a car?
Yes.
And according to you, this man threatened you and your infant daughter?
Correct.
He threatened your lives, you said?
He implied it, yes.
In 2011, when this supposedly happened, you didn't tell anybody about this supposed threat to yourself and your baby daughter?
I told my close friends.
Well, according to you, that threat happened while you were on the way to exercise class?
Correct.
And right after it supposedly happened, you say you actually went to that exercise class?
I didn't go to the class. I went to the restroom in the class.
You went to the restroom after that you went to the class, right?
No, I did not return to exercise class. I waited until they were done with the class.
But you not tell anybody at that class? You didn't tell your instructor that you had just supposedly been threatened?
No, I lied to her and told her that my baby had a blowout in her diaper. That is why I was crying in the bathroom.
You didn't tell anybody else in the class about it?
No, they left before I came out of the bathroom anyway.
You never before this instance said you were crying about it, did you? That was the first time you ever said that?
No, it's not.
1 minute. Isn't it true that you wrote about this in your book, right?
Yes.
And you said that you went right to the bathroom and you must have looked crazy because the instructor yelled after you. Are you okay? Right?
Correct.
You said you responded, "She had a blowout, I'll be there in a minute."
I was afraid to tell anyone. I was alone in the bathroom. I held my baby close instinctively, covering her head as I stared at myself in the mirror.
You were shaking still, but less now, correct?
Correct.
You didn't say I was lying and the instructor saw me crying, did you?
Yes, I did. I said she had a blowout. That is a lie. That is not telling the truth.
Then, in fact, in the same book, you said that I went and did the class, told no one what happened in the parking lot, right?
Yes, I went to the class afterwards. Everybody was gone. Told my instructor that she had an accident, and that was it.
When you wrote, I went and did the class, you didn't mean to say I did the exercise class?
It was incorrect. I did not do the class.
So you wrote a book saying that you did the class, and now you are saying you didn't do the class.
I did not do the class. There is no way I could have possibly done exercises as scared as I was.
In any case, you didn't tell anybody in the class about it, right?
No, but I wasn't close with those women anyway.
You didn't call the police, did you?
No.
You didn't even tell your husband, who was the father of the child who you claim was threatened, right?
Correct.
The first time you publicly told this story that was about a supposed threat to your life was in 2018, right?
I don't remember.
Well, it was on the Anderson Cooper show, wasn't it?
I know I had told it before that because a colleague told it in an interview she did about me. She was the only person that I called that day or the next day after it happened.
At the time, though, in your book, you said you told no one, right?
Yes.
Now you claim you told a colleague?
Afterwards, not that day.
But you wrote you told nobody about this story?
Which I said in the book, as you just read, I told nobody about it that day or the days that followed.
This is actually pretty representative of how every inconsistency went on cross-examination. The defense would show a past interviewer document that is contradictory to her current account, and Daniels would say that the phrasing in the past document is being misinterpreted and that it supports her current account. All in all, she did a pretty good job in not giving the defense any clear wins on cross-examination. In this instance, however, the defense found an audio recording between Michael Cohen and Daniels' former lawyer Keith Davidson, where Davidson says that Daniels, her agent, and her new lawyer, Michael Avenatti, invented the encounter with the man in the car.
Avenatti's lying his ass off, as you know, and I know, and Gina knows. And Stormy knows. And Stormy's lying. Right?
Are you speaking with Gina?
On occasion. We went a long time without speaking. You know, Gina brought Stormy to Avenatti. And we went a long time without speaking. And now that Avenatti has really driven a wedge, a serious wedge, in between Stormy and Gina, Avenatti is leaning on Gina, saying, you know, basically, we know we're lying. We know we're full of shit in the media. We know that she was never threatened in Las Vegas. We know all these things.
But why would Daniels lie about the encounter in the first place? The defense posits that it's to cover up her real reason for wanting the NDA and later publicizing her story anyway. the defense say that Daniels sold her story to make money. Here, they quiz her on the timing of the publication.
In 2011, your story wasn't worth much money?
I don't know what it was worth. I turned down many offers.
You turned down or tried to get $15,000, you couldn't get that?
Correct.
Now, in 2016, you say that you were afraid, but the story was worth a lot of money for you now, right?
Correct.
And you then had Gina Rodriguez go out and try to sell the story, right?
Correct. I didn't care for how much. I just wanted the story out there, which is why I had a press conference set up for free.
And you didn't give a free press conference, did you?
I didn't have to.
You were looking to extort money from President Trump, right?
False.
Well, that's what you did, right?
False.
When you say this fear that you say you were under in 2016 is based on the supposed incident that supposedly took place 5 years earlier that you still hadn't told anybody publicly about, right?
It was not a supposed incident. It was a true incident. I had told a lot of people.
You hadn't told your husband, right?
No.
And then so because you had that fear, you decided to do exactly the opposite of what that person had told you to do, right?
Correct.
So you weren't really very scared, were you?
I was terrified. I decided to change my tactic. It was a new ball game. There's a big difference between a reality TV star and someone running for office.
The truth is, you saw your opportunity to make it known. You had Gina Rodriguez try to sell your story to the National Enquirer.
I saw my opportunity to get the story out. I didn't put a price tag on it. That is why I did every interview for free.
At this point, you were asking for money. You wanted money from President Trump, right?
No.
You weren't asking for money in 2016?
I never asked for money from President Trump.
You asked it from Michael Cohen, right?
No. I never asked for money from anyone in particular. I asked for money to tell my story.
And that's what you're asking in 2016 was for money to be able to tell your story, right?
I was asking to sell my story to publications to get the truth out.
But you entered into a negotiation over a non-disclosure agreement, right?
My attorneys did, yes.
And that was your choice, right?
No response from the witness.
Well, you made the decision that you wanted your lawyers to do that, right?
I accepted an offer.
That was your choice, right?
Not necessarily. I wanted to do a press conference.
You would prefer to do the press conference and get no money over making money. Is that what you're saying?
Absolutely, if it got the story out.
So why didn't you do that?
Because we were running out of time.
You were running out of time to get money, right?
No, to get the story out.
You could have gone out any day of the week, could have walked out of your apartment, out of your ranch home, and given a press conference, right?
I could have.
But you chose not to, right?
I chose to be safe.
You chose to make money, right?
No response from the witness.
Right.
I chose to take the non-disclosure.
Even Michael Cohen said that at the time, he thought it was an extortion attempt. Cohen also recorded a call with Davidson, where Davidson claimed that Stormy Daniels may have been ever so slightly interested in the money.
I just didn't want you to get caught off guard, and I wanted to let you know what was going on behind the scenes. And I would not be the least bit surprised if, I wouldn't be the least bit surprised if you see in the next couple days that Gina Rodriguez's boyfriend goes out in the media and tells a story that Stormy Daniels, in the weeks prior to the election, was, basically yelling and screaming and calling me a pussy.
Can I ask you a question? Right.
No, hold on 1 second. I wouldn't be the least bit surprised if he comes out and says, you know what? Stormy Daniels, she wanted this money more than you can ever imagine. I remember hearing her on the phone saying, you fucking Keith Davidson, you better settle this goddamn story, because if he loses this election, and he's going to lose, if he loses this election, we lose all fucking leverage. This case is worth zero, and if that happens, I'm going to sue you because you lost this opportunity. So settle this fucking case. That's a far cry from being, bullied and pushed into settling a case.
Right.
Daniels also monetizes her position of being publicly opposed to Trump. She sells a variety of anti-Trump merchandise on her website and has gone on a strip club tour, which she named after Trump's campaign slogan. She says that back in the day, when she was stripping, it was generally middle-aged white men who would come and see her. Nowadays, however, there are many more women, gay couples, immigrants, and other social liberals who despise Trump. She has also made money from her book, a documentary based on the book, and she charges people to attend viewing parties where they watched the documentary with her. She also has one other rather strange source of income.
And there's another way you're making money now, which is by telling people that you have the ability to communicate with ghosts and dead people, right?
I work on a television show called, well, the title had changed, but it used to be called Spooky Babes.
Well, my question was, are you making money by telling people that you have the ability to communicate with ghosts and dead people?
Well, I am making money. Well, I haven't made any money yet, but the idea is to make money on a television show about the paranormal and UFOs and the unexplained.
Well, you have made a show and podcast claiming that you can speak to dead people, right?
I have been on lots of podcasts.
Well, my question.
Which podcast are you referring to?
Are you saying you have not made a show or a podcast telling people that you can speak to dead people?
Yes, we are talking about the paranormal, yes.
And you also claimed that you lived in a house in New Orleans that was haunted and that the spirits that are in the house attacked your boyfriend and held him underwater, right?
Yes, so the house has some very unexplained activity. We brought in experts, people to measure the electromagnetic fields, the religious experts, scientists, people to check for gas leaks. So yeah, it was a lot of interesting and unexplained activity. So I created a whole entire show. A lot of the activity was completely debunked as, a giant opossum that was under the house, for instance.
And you have been making money off of your claim that you are a medium and that you can talk to the dead, right?
I am making money I am part of a ghost hunting team that we go into locations, yeah.
And you read tarot cards for clients, correct?
Yeah, a lot of my fans like to do things called high tea and tarot with Stormy Daniels, and we read tarot cards together.
And you charge people for that, right?
Yes.
And you claim to be able to speak to people's dead relatives, right?
I make them agree that it's all entertainment, right.
And that's what you charge them for?
Yes.
But you tell people that that's what you can do, right? Speak with their dead relatives, right?
Yes.
And that's what you have made money off of, right?
One of the ways, yes.
Finally, Daniels has at least one really, really good reason to hate Trump. She owes him hundreds of thousands of dollars. There were numerous civil lawsuits between Daniels and Trump, and the net result of them all is that Daniels owes Trump about $550,000 in legal fees. She has refused to pay it since she thinks it's unfair. So the defense say that Daniels is lying about the affair and about the encounter with the man in the parking lot, that the whole NDA agreement was just an extortion scheme to get some quick money, and that Daniels has kept the lie going since she hates Trump and makes money from being opposed to him. Moving to the building, we're going to start with wall number 1. Here the prosecution put forward evidence that the information in the documents is factually false, making them false business records. The documents claimed that Cohen was getting paid for work he was doing for Trump pursuant to a retainer, and the defense say that this is accurate. During 2017, Michael Cohen was the personal attorney to President Trump, and the defense claim that he was paid for that. The amount of work that Cohen did for Trump that year is certainly relevant to help us determine if it is pay for services rendered or a way of hiding the reimbursement. Here is how Cohen quantifies the amount of work he did that year on direct examination.
I want to talk to you a little bit about the work that you did in 2017. Any work that you did with respect to your role as personal attorney and personal counsel to President Trump. Did you do, in the year 2017, any work for Mr. Trump or for his wife Melania Trump?
Minimal.
And can you just give us some examples of the minimal work that you did in 2017 for them?
There was a matter that dealt with an individual by the name of Summer Zervos. I was working with Mark Kasowitz on that, and so I had spoken with Mr. Trump in the Oval Office and provided him some documents that Mr. Kasowitz had given to me to pass along. As far as Melania, I think it had to do with some trademarks or maybe even a Madame Tussauds agreement.
So let's break both of those down. In terms of the work that you did for Mrs. Trump related to Madame Tussauds or the trademark, what was the... Can you characterize the extent of that work for Mrs. Trump?
I reviewed an agreement that Madame Tussaud sent to her that was to create her likeness and image for their museum.
Was it a substantial amount of time that you spent on that?
No, ma'am.
And did you send a bill or an invoice to Mr. Trump or to the Trump Organization for that work?
No, ma'am.
Why not?
Well, one, I didn't expect to be paid on it, but it wasn't enough work to have me send an invoice.
And you mentioned Summer Zervos. Who was handling that matter substantially for Mr. Trump?
Mark Kasowitz.
So that was an outside attorney, not yourself?
Correct.
How would you characterize the amount of work that you did generally on that matter, if any?
Very minimal.
Did you ever bill Mr. Trump or the Trump Organization for that minimal work that you said that you did on that?
No, ma'am.
Why not?
Again, it wasn't any substantial work. Mr. Kasowitz was actually doing the work on that. Plus, I didn't expect to be paid.
If you had to characterize or estimate the number of hours that you spent in the year 2017 doing any sort of work, legal or these quasi-legal matters, what would be the total number of hours that you would estimate?
Less than 10.
Now, did you bill for any of those matters?
No, ma'am.
Was the $420,000 that you received from Mr. Trump and from the Revocable Trust, did that have anything to do with the minimal amount of work that you did for Mr. Trump in 2017?
No, ma'am.
After that, it was the defense's turn to question Cohen. Their goal was to show that substantially more work was done than Cohen just admitted to. Let's see how they did.
You changed roles, so you leave the Trump Organization and you start as President Trump's personal attorney. You continue to do what you were doing in February of 2017, right? Helping President Trump with his personal legal issues, right?
Yes, sir.
You had a matter with Mark Kasowitz representing President Trump, right?
Yes, sir.
You and he were actually lead counsel on that case, right?
I think Mark Kasowitz was lead counsel.
Well, let's take a look at B-176 just for you, the court, and the parties. So isn't it true that both you and Mr. Kasowitz were both lead counsel on that matter?
Yes, sir.
And that was, at the time, a relatively active matter that was taking a fair amount of your time, and it looks like Mr. Kasowitz's time, right?
Yes.
So one of the things that you did as President Trump's attorney was to help him find a lawyer to actually work the case, right?
Yes.
So in the case that we just talked about with Mr. Kasowitz, you were co-lead counsel with him, right?
Yes, sir.
But in some other cases, you maybe wouldn't have handled the case yourself if it wasn't your area of expertise, but you would represent President Trump in getting a lawyer to help him, right?
Correct.
And do you recall doing that in January and February of 2017 for President Trump?
Yes.
For example, there were issues at the time with reporters potentially making defamatory statements against President Trump, right?
Yes, sir.
And you helped, that was part of your job, right? To help with that?
Yes, sir.
And you have met regularly with counsel, including Mr. Kasowitz, in February as well, on not only the case you were lead counsel on, but some other matters as well, right?
Yes, sir.
And there was, just so the jury understands and to help us understand, that was a case that actually had legal filings that had to be made, right?
Yes.
So it wasn't just like a threat of litigation, there was ongoing litigation with legal filings, right?
Yes, sir.
And you were part of that?
Yes.
Your role changed, is that fair? Is that what you said?
Yes.
Okay. So certainly talking about January and February, you were actively a part of that, correct?
Yes.
And then the filings in March, you helped with the filings, correct?
I reviewed the documents, yes.
Well, is reviewing the documents helping with the filings?
Yes, sir.
All right. Do you recall helping President Trump even serving subpoenas on government agencies, like helping figure out how to serve a subpoena on a State Department? Do you recall helping with that?
No, sir.
Well, let's take a look at B-237 and just review that for the parties and the court. So, do you recall working with Mr. Kasowitz around subpoenas that had been issued, including the State Department?
I received the email from them, yes.
Well, when you received an email like that and you were President Trump's attorney, would you have known something about it?
Yes.
So that was just my question, whether that was one of the things that you were doing at that time, was helping President Trump with that type of issue.
Yes, sir.
You also did a fair amount of legal work for the First Lady in 2017, correct?
I did legal work for the First Lady.
There was an issue with Madame Tussauds, correct?
Yes.
And you helped with that?
I reviewed the agreement, yes.
And reviewing the agreement is helping with that?
Yes, sir.
You also met with the First Lady on many occasions, at least in February and March and April of that year, right?
Yes, sir.
Did you meet with the First Lady in New York?
Yes, sir.
Because she was still in New York at that time?
Yes, sir.
And part of your role in meeting with her was helping her with legal issues or potential legal issues, correct?
No, sir.
Well, was the Madame Tussauds a legal issue?
That was...
Was there Do you recall there being a trademark issue that arose involving Melania during that time period?
Yes, sir.
And did you help with that situation?
I did.
And again, that's legal work you were performing for the First Lady, right?
Yes, sir.
But you separately met with her on multiple occasions for non-legal work as well, right?
Personal matters.
And did you view that as part of your job?
Yes, sir.
So, part of your job had always been, or at least for many years, had been not only doing legal work, but helping President Trump and his family with an array of issues, right?
Correct.
And your job was being President Trump's lawyer, correct?
Yes, sir.
There separately seems to be an indication in the ways that the payments were moved that Cohen was in fact getting paid for his work as personal attorney to the president. The first 3 checks were paid from the Trump Org Trust, which is the entity that controlled the Trump organization while Trump was president. But then, somebody realized that given that Cohen was the personal attorney to the president, he should be getting paid from Trump's personal expense account. So the rest of the checks were issued from that account. This series of events is more consistent with Cohen being paid for services rendered than it being a payment that is trying to be hidden somewhere in the Trump organization. If the $420,000 was a payment to Cohen for work that he was doing and it was unrelated to any repayments, then the entries on the business documents are now true. There is no crime and Trump must be found not guilty. Even if one doesn't believe that Cohen did any work for Trump at all in 2017, that doesn't actually matter. When you have a retainer agreement with a lawyer, you have to pay them, even if no work comes up. In fact, Cohen was paid $1.2 million by a Swiss medical company for a retainer for which he did no work and only met with them 6 times total. Now, there was no written retainer agreement, and the court did not explicitly outline what the law counts as a binding retainer agreement in New York, but the defense did manage to get Keith Davidson to talk about the agreements he has with his clients.
And so you served as a conduit to help get this story down?
I was asked. I was in essence retained to use my best efforts to get that blog taken down, yes.
And you said, in essence, retained. You were, in fact, retained by Stormy Daniels in connection with that engagement, right?
Yes.
And that engagement, the attorney-client engagement, was not committed to writing, was it?
It was not.
And there's nothing wrong with that, is there?
There is not.
That's an ethical practice, to have an attorney-client relationship without an engagement letter, right?
Yes.
And you also worked to have the Daily News take down their internet article reflecting Ms. Daniels' allegations, correct?
I believe so.
And in connection with that effort, you working to get the story from the Daily News down, you were also acting as Ms. Daniels' attorney, right?
Yes.
Still no retainer agreement, right?
Correct.
Did you ever have an engagement letter with Ms. Daniels?
Yes.
Was that in 2016?
Yes.
Cohen was also questioned on his past retainers.
And you never had a retainer agreement with any of those individuals, did you?
No, sir.
And the reason why you didn't have a retainer agreement is because you didn't need one, right?
Correct.
And you didn't need one because you were employed by the Trump organization, correct?
That's correct.
And so you knew you were going to get paid, right?
Yes.
And there were some parts of your salary you didn't know that would be bonus? You knew your salary?
Yes, sir.
So you didn't have to worry when you did personal work for Donald Trump Jr. about a retainer agreement because you were getting paid by the Trump organization, correct?
Correct.
Now, you testified multiple times on Tuesday that when you were President Trump's personal attorney in 2017, you had no retainer agreement, right?
Correct.
But the truthful testimony is that in the whole time you worked for the Trump organization, you never had a retainer agreement, correct?
I never had a retainer agreement.
So it's not just January 2017 that you did not have a retainer agreement. It is from the day you never went back to your law firm, and the Trump organization sent some guys over and packed up your bags, and you started working for Donald J. Trump, and you never had a retainer agreement, right?
No, sir.
Is there anything wrong in your view? You were a lawyer, right?
Yes, sir.
You were acting as a lawyer the whole time you worked for the Trump organization?
Well, I did legal matters and non-legal matters.
Understood. But you did legal matters?
Yeah.
And ethically, there was nothing wrong, correct?
I was an employee of the Trump organization, nothing unethical.
Right. So when you were an employee, you had a job with the Trump organization, right?
Yes, sir.
And your job was to report directly to President Trump, right?
To whatever Mr. Trump wanted me to do.
You were an executive vice president, right?
Right, yes, sir.
And if that direction included doing legal work for Melania Trump, for example, you did it, right?
Yes, sir.
And ethically, nothing wrong with that, correct?
Correct.
Because under New York ethics rules, you don't need a retainer agreement to do work for a client, do you?
No, sir.
We can also see in an email after Cohen became the personal attorney to the president that Alan Weisselberg asked him to set up an agreement they discussed. That certainly would be a strong indication that they discussed a retainer and had a verbal retainer agreement. So, if there was an oral retainer agreement and it was valid and Cohen was paid according to that, then there are no false business records, no crime, and Trump is not guilty. If the inaccuracy of the business records are shaky and looking at the evidence from both sides, it was not proven beyond a reasonable doubt, then Trump must be found not guilty. This wall is an example of the defense putting forward their own theory of events and arguing that the evidence fits it better. But they don't actually need to do that. They just need to raise a reasonable doubt in the story put forward by the prosecution. And a great way of doing this is by showing witnesses to be non-credible. Michael Cohen is all over this case, and if he is believed, that alone is nearly enough to find Trump guilty. So it is vital for the defense to show that Cohen is wrong or lying. He was on the stand being cross-examined for multiple days. Let's see if and how the defense discredited him. We just saw on wall 1 an example where we could compare what he said to the prosecution about the amount of work done in 2017 and what he admitted to the defense afterwards. These two were certainly contradictory, but Cohen was caught out some other times too. Here is how Cohen described the magnitude of his payment to Daniels on direct examination.
At some point, did you have a conversation with Mr. Trump about the fact that you were willing to pay for it, at least initially?
Yes, Alan and I spoke to Mr. Trump. We expressed to him that I was going to front the money for it, to which he was appreciative and good.
Did you have a sense from Mr. Trump that you would end up being out the money or you would get paid back?
He stated about it. Don't worry about it. You will get the money back.
Would you have ever paid for the NDA for Stormy Daniels on your own without an understanding that you would get paid back?
No.
Why not?
It's $130,000. I was doing everything that I could and more in order to protect my boss, which was something I had done for a long time. But I would not lay out $130,000 for an NDA needed by somebody else.
So, it's quite a substantial amount of money. Cohen would not have paid it without being assured he would be reimbursed. However, a year later, Keith Davidson calls Cohen, and Cohen himself decides to record the phone call. Davidson is calling Cohen to tell him that the bank is questioning him about the wire that he received from Cohen's shell company, Essential Consultants.
I just thought,
That's just
honestly,
so interesting because the amount was just not really that significant.
Correct. Yeah, it was. I can look it up, but it was 100, 120 or something.
No,
like
I
that.
think it was like 135 or something like that.
Yeah.
So it seems like the payment is not that big in the view of Cohen and Davidson, who are both well-paid lawyers. Cohen did take the money out of a home equity line of credit, but he admitted that this was just to hide the payment from his wife and not because he actually needed a loan. It's worth keeping in mind that at least at the time of the payment, Cohen was very wealthy. In the 5 years preceding the payment, he made $375,000 in base salary and got a $150,000 bonus each year. He also made millions from taxi medallions which he owned. In 2018, he had to pay restitution for unpaid tax between 2012 and 2016, which summed to $1.394 million. So that $130,000 payment was just 10% of what he was underpaying in taxes. The payment was not very substantial for him. The defense say that Cohen is bigging up the size and importance of the investment and is lying on the stand. Cohen testified on direct that he recalls a call in October where he updates Trump on the Stormy Daniels deal and tells Trump that he would fund it himself. This is a strong piece of evidence. It points directly towards Trump's knowledge and involvement. The only problem is that the defense found something in the call logs to dispute this story.
Do you recall testifying in response to conversations from the prosecutor about the phone call you had with Mr. Schiller at 8:02 p.m. on the 24th, 2 days earlier? Do you recall testifying about that?
Yes, sir.
You recall saying that you called Mr. Schiller on that evening because you wanted to speak to then Mr. Trump, right?
Correct.
You wanted to speak to President Trump to discuss the Stormy Daniels matter and the resolution of it. That was your testimony, right?
That was...
Then you testified just a couple of days ago that you were successful. You called Mr. Schiller and you had a conversation. And in that conversation, you resolved you were moving forward to fund the deal. Correct?
Correct.
Can you explain to us how that works? You know that Mr. Schiller is with President Trump, and so you know that you can call his phone, and that Mr. Schiller just hands President Trump the phone?
Yes, sir.
Can you tell from your conversation with President Trump whether he was on speaker or whether you were just talking to him?
I didn't take notes.
So you don't recall either way?
No, sir.
But you recall that on that call, I don't want to put words in your mouth, you discussed the Stormy Daniels matter and the resolution, and you also discussed the conversation would be that it was resolved, that you were going to move forward and fund the deal, right?
Yes, sir.
That was your testimony?
Yes, sir.
Do you remember? I appreciate this goes back a while. Do you remember at that time, October 22nd, 23rd, 24th, 2016, you were receiving a bunch of ongoing and continuing harassment phone calls? So somebody was calling you constantly. Do you remember that?
Yes, sir.
And do you remember that on the 24th, at around 7 o'clock at night, the person who was harassing you forgot to block the number, and you got the number? Do you remember that?
No, sir.
Do you see your text to this number that says, "This number has been sent to Secret Service for your ongoing and continuous harassment to both myself as well as to the organizations named on it"?
I do.
That is at 7:10 p.m., right?
Yes.
And then the text back says, "It wasn't me. My friend told me to call. I am sorry for this. I won't do it again," right?
Yes, sir.
Then you respond and said, "They're going to have to explain that to the Secret Service because you have been receiving dozens of these harassing calls over the past 3 days," right?
Correct.
If you are a minor, I suggest you notify your parent or guardian. That's what you said to them, right?
I did.
The person texted you back and said, "I didn't do it. I am 14. Please don't do this." You eventually said to have their parent or guardian contact you.
When they expressed they were 14, I felt it was proper.
That was at 7:24 p.m. on that same date, October 24th, right?
Correct.
So that whole exchange was between around 7:10 and 7:24 p.m.?
Correct.
That was an exchange because you had been receiving a bunch of harassing phone calls the prior 3 days?
Correct.
Do you recall at 7:48 texting Keith Schiller about this 14-year-old? Do you recall that? Do you recall that?
I don't recall.
Do you recall texting Keith Schiller at 7:48 p.m.? "Who can I speak to regarding harassing calls to myself in office? The dope forgot to block his call on one of them." You don't? Do you recall at 8:02, your initial text to Mr. Schiller is at 7:48, and then at 8:02 he says, "Call me," to you, right?
Yes, sir.
That shows a voicemail at 8:01 from Keith Schiller to you?
Yes, sir.
And then at 8:02 he says, "Call me." And then it looks like you then call him at 8:02 for 1 minute and 36 seconds, right?
Correct.
This is the call that you testified about on Tuesday, that you had a conversation with President Trump, that you called Keith Schiller It wasn't to talk to Keith Schiller, it was to talk to President Trump about the Stormy deal and the moving forward. That was your testimony.
Yes, sir.
You call him back at 8:02 for 1 minute and 36 seconds. At 8:04, you text him the number of the 14-year-old who was prank calling you, correct?
I did, yes.
Immediately he texts you back within a few seconds. He said, okay?
Yes, sir.
The very next morning at 7:58 a.m., you say, did you reach the family, right?
Yes, sir.
When you testified on Tuesday that you had a specific recollection that 1 minute and 36-minute phone call on October 24th was not with Keith Schiller, that you called Keith Schiller and he passed the phone to President Trump, you finalized the deal with Stormy Daniels and you said, we're going to move forward. And he said yes, because you kept him informed all the time. That was your testimony, right?
That's correct.
That was a lie. You were actually talking to Mr. Schiller about the fact that you were getting harassing phone calls from a 14-year-old, correct?
Part of it was the 14-year-old, but I know that Keith was with Mr. Trump at the time, and there was more than potentially just this. That's what I recall based upon the documents that I reviewed.
5 minutes ago, I asked you if you remember harassing phone calls, and you said no. And then I refreshed your recollection. It's totally fair if you don't remember. But now your testimony is that you were testifying truthfully on Tuesday to a 1 minute and 36-second phone call, and you had enough time in that 1 minute and 36 seconds to update Mr. Schiller about all the problems you were having with these harassing phone calls, and also update President Trump on the status of the Stormy Daniels situation because you had to keep him informed, because every time you made any decision, you ran it by the boss. That's your testimony?
I always ran everything by the boss immediately, and in this case, it could have just been saying everything is being taken care of. It's going to get resolved.
That's not what you testified to on Tuesday. You said you had a recollection of a phone call on October 24th at 8:02 p.m. where you called Mr. Schiller and he gave the phone to President Trump, and you told President Trump about the updates, that you were moving forward with the funding, and he said, okay, go. That was a lie. You did not talk to President Trump on that night. You talked to Keith Schiller about what we just went through. You can admit it?
No, sir, I can't. I'm not certain that is accurate.
You were certain it was accurate on Tuesday when you were under oath and testifying. You were certain it was accurate you had a phone call to President Trump. But now you are saying you are not certain it was accurate.
Based upon the records that I was able to review, in light of everything that was going on, I believe I also spoke to Mr. President Trump and told him everything regarding the Stormy Daniels matter was being worked on, and it's going to be resolved.
If Cohen is indeed lying about that, how can we trust anything else he says about Trump's involvement? Cohen also testified that he did not want to work in the White House, but he would have liked to be offered a role which he would then turn down. He felt that he deserved this, given his contribution to Trump's campaign. The defense think that he actually wanted the role, and feels slighted that he didn't get one.
Do you remember telling Congress that it was a lie, that you did not want to go to the White House? Do you remember saying that to Congress?
I remember telling Congress I did not want to work in the White House.
Well, do you remember saying what you testified to on Tuesday is that you didn't want to go to the White House?
Yes.
And that you wanted to continue in the role as President Trump's personal attorney, right?
Yes, sir.
And that you were offered jobs in the White House, right?
I was offered a role, yes.
You also testified that you were present when President Trump reamed out Mr. Priebus because you hadn't taken a job that you were offered, right? And that job was a job we talked about a minute ago in the White House counsel's office?
Correct.
But the truth is, Mr. Cohen, you really wanted to work in the White House, correct?
No, sir.
You didn't simply indulge friends and family about working in the White House like you testified about. You really wanted to work in the White House, correct?
Again, no, sir.
You hoped that you would be named the White House Chief of Staff. Not just be considered, but be named the White House Chief of Staff, correct?
No, sir.
Are you familiar with somebody named Spencer Zwick?
Yes, sir. I know Spencer Zwick.
Do you recall having a conversation with Mr. Zwick where he asked you whether you wanted to be Attorney General Cohen or Chief of Staff, and you answered Chief? Do you recall that?
Yes, sir.
And that was still during the campaign, correct?
Correct.
And then after President Trump was elected in November, he congratulated you and he said Chief of Staff. And you said that would be nice, correct?
Correct.
Are you familiar with somebody named Rita Vaigman?
Yes, sir.
And do you recall on November 9th, so right after the election, you told her that she was going to come to the White House with you to be your assistant to the Chief of Staff. Do you remember saying that?
Yes.
And then a few days later, November 12th, so still November 2016, You had a series of communications with a family member, with your daughter, where you discussed whether you still had a chance at the chief of staff position, right?
Amongst other texts, yes.
And your daughter actually alerted you to the fact that she read that there was a consideration that Mr. Priebus would be chief of staff. And you said he is pushing like a madman, right?
Yes, sir.
And then there was a continued conversation about whether you still had a chance to be chief of staff. And you said there was still many opportunities, right?
Yes, I think I also used the word hybrid.
The defense also tried to show that he was lying about not wanting other roles in Trump's administration, but they were much less effective than this example. So, we have a number of times that the defense have pointed to Cohen lying on the stand, which can put his entire testimony in question. But they also have a theory as to how and why he did it. At this point, Michael Cohen doesn't like Trump, and he has a podcast where he often talks about Trump in a negative light. He makes money from publicly discussing Trump. He makes money from his podcast and also sells merchandise on his website, which is, let's say, not particularly complimentary of Trump. He released a t-shirt to celebrate Trump's indictment and arrest, and also merchandise supporting Biden, labeling Trump a fascist, and supporting sending him to jail. The 45 on the merch refers to Trump, by the way. He was the 45th president. But even if Cohen hates Trump and is willing to lie on the stand to help find him guilty, how did he pull it off? There were some discrepancies in his testimony, but for the most part, the story matched what others were saying. Well, for this, we have to look at the trial schedule, and we can see that he was one of the last to testify, so Cohen could have kept up with the prior testimony of others and molded his story to fit with what they have said. Obviously, that's just a defense theory. I mean, unless Cohen admits to following the trial before testifying. Hey, what's this?
Mr. Cohen, you have been following what's happening in this trial, correct?
To some extent, yes.
Well, for example, details around the jury selection process, correct?
I have made comments about the jury selection.
Now, on April 23rd of this year, so after the trial started, you said that you had actually heard what a witness had testified about, correct?
Objection, Your Honor.
Overruled, you can answer.
It's possible, yet.
Well, do you recall testifying? Do you recall saying on TikTok on April 23rd, and that's when Mr. Pecker was still on the stand, that from everything that you heard from people today, David Pecker is corroborating what you have been saying for 6 years. Do you recall saying that?
I do, yes.
And that's because you heard from people about what Mr. Pecker had testified to in this trial, correct?
Yes, somebody had called me and told me that Mr. Pecker had corroborated what I have been saying for a long time.
And it's true that you also have been following what's happening in this courtroom on CNN and MSNBC, correct?
I have seen CNN and MSNBC, but I'm not following the trial.
Well, Mr. Cohen, you have been watching CNN and MSNBC during this trial, correct?
I have been on CNN and I have watched CNN and MSNBC, but not religiously, in order to follow the full extent of the trial.
And you have said that you are watching on CNN and MSNBC, maybe not all the time, about some of the things that are happening during this trial, correct?
I've turned it on, yes.
And that's because this trial is important to you, correct?
I do it because at times there are other issues as well that I'm interested in seeing what's happening, like the protests or Israel, and this issue comes up as well.
Well, is this trial important to you, Mr. Cohen?
Personally, yes.
So the defense claim that Cohen is fabricating his testimony. They say that Cohen can't be trusted because even according to him, he's an admitted liar. He lied to his wife about the Daniels payment. He lied to his bankers to set up the shell companies for the hush money settlement. He lied to the FEC, prosecutors, and reporters for about a year when he was trying to cover up the payment, and he is a convicted felon, guilty of lying to the Congress and lying to the Senate. He's also a self-professed thief. Cohen says that he was reimbursed for the Stormy Daniels payment and for some money he put forward to Red Finch. They had done some consulting work for Trump, and Trump had refused to pay them. Cohen was friends with the CEO, so he settled the matter by paying the CEO a smaller amount than the full $50,000. Then, in 2017, he got paid back for the full amount by Trump, pocketing the difference. Cohen says he did this since he didn't think that Trump deserved the discount that he had negotiated with Redfinch. This is basically theft. The defense say that Cohen is a liar and a thief and that he lied on the stand. But there's another reason that Cohen's evidence is weak. Cohen is a co-conspirator in creating false business documents, and he has spent time in jail for falsifying documents related to this case. According to New York law, you can't use just the testimony of a co-conspirator to find someone guilty of conspiracy. That means that even if you believe everything that Cohen says, unless it is corroborated by other evidence, you can't use Cohen's statements alone to find Trump guilty. If the defense have shown that Cohen is unreliable, then the jury should just disregard his testimony completely. The prosecution also put forward evidence that Trump acted with others in the Trump organization to create false business documents. They have to prove this beyond a reasonable doubt. However, when we analyze these 34 documents, we can see there are some weaknesses in this theory. There are 11 invoices which were emailed from Michael Cohen to Alan Weisselberg at the Trump organization. They weren't sent to Trump. Trump didn't see them pop up in his inbox. There is no reason at all that Trump would have seen the emails. The prosecution did provide evidence from Deborah Tarasoff and Rebecca Minocchio that it was practice in the Trump organization to staple the invoices to the checks. The signer would then read the invoices and sign the checks. However, Tarasoff didn't say that she had a specific recollection of preparing the 11 checks in question this way. So there was no direct testimony in the trial that Trump ever even saw the invoices. There are also 12 vouchers which were created by Deborah Tarasoff in the MDS system. Tarasoff would have seen them, McConney would have seen them, other accountants at the Trump organization would have seen them, but there is no reason at all that Trump would have seen them. In fact, there was not a single piece of evidence in the whole trial that showed that Trump knew the MDS system even existed, let alone that he knew about the 12 vouchers that he's charged for. Finally, we have the checks. Trump didn't sign the first two, and there is no evidence that he knew that Alan Weisselberg and Donald Trump Jr. signed them. For the checks he did sign, it really comes down to whether he was paying meticulous attention when he was signing them, or if he was just signing them carelessly. We have already heard testimony from Pecker that Trump would sign checks while having a separate conversation with him. This would obviously limit the amount of attention Trump could put towards analysing the checks. Pecker's recollection was from Trump Tower, and one would imagine that when Trump was president, he had even less time to sign checks, which makes it more probable that these 9 checks were signed while Trump was multitasking. Madeleine Westerhout worked in the White House with Trump, and she shared her recollections of Trump signing checks.
And with respect to the checks, they came in a folder, am I correct?
Yes.
And if he had the time when you gave them to him, he would sign them?
Yes. If he had the time and if he was in the office, yes.
And you said he signed a tremendous amount of items, right?
Yes.
And there were proclamations that he was signing?
Yes, commissions, proclamations, executive orders, memos, letters.
And that would take up many hours of his day, right?
Yes.
Because he did not like to have that in printed form, right?
No.
And were there times, with all these, would you say it was hundreds of documents that he was signing?
Not every day, but sometimes,
And this was in between other things that he was doing, right?
Oh, yes,
And so, would you see him signing things without reviewing them?
Yes.
And would you see him signing checks without reviewing them?
Yes.
And you would see him signing checks while he was on the phone, right?
Yes.
Would you see him signing checks when he was meeting with people?
Yes.
And there were different types of people that he was meeting with, right?
Yes.
Sometimes he was meeting with the top foreign leaders in the world, right?
Yes,
And other times he was meeting with you.
Yeah,
And so he wouldn't be signing the checks when he was meeting with the top people in the world?
Yes.
But maybe when he was meeting with you, talking about something else, he would also be signing documents?
Yes. Talking about the schedule or anything that had been going on.
The chief of staff that he would be meeting with?
Yes.
And other people he would be doing that?
That's right.
He was a person who multitasked, right?
Definitely.
The prosecution couldn't prove that Trump knew about the invoices, the vouchers, and the first 2 checks. And they couldn't show that he didn't just mindlessly sign the last 9 checks. All of that is reasonable doubt. The prosecution had to prove beyond a reasonable doubt that Trump acted with others in the Trump organization to create the 34 documents. They couldn't even prove that he knew any of them existed. This wall of Trump's guilt is incredibly weak, and it cannot support a finding of guilt. Now, when it comes to the conspiracy to influence the election, the prosecution put forward evidence showing that there was a conspiracy and that there was at least one illegal means. But the defense say that there was no illegal conspiracy. There is nothing wrong with conspiring to influence elections. That's all that campaigns do. They work as a group to influence elections. The prosecution made a huge show out of all the different elements of Trump, Cohen, and Pecker's plan. But this was just business as usual for AMI. And if we compare what they did for Trump to what they did for other politicians and celebrities, we see that Trump didn't get any special treatment. The prosecution made a huge stink about positive stories about Trump and negative stories about Trump's opponents, which were published in the National Enquirer. They said it was part of a conspiracy. However, on cross-examination, Pecker explained exactly why the positive stories were published.
You actually participated in those meetings. In quantitative assessment of how AMI was going to make money based on stories was something that you were personally involved in?
Yes, I was.
And focused on?
Yes.
And I think you said on Tuesday that by that time, the Celebrity Apprentice, the research showed that President Trump was the top celebrity in terms of helping sell the National Enquirer?
Absolutely.
And so that's the Celebrity Apprentice that we are talking about in the early 2000s, correct?
Yes.
And that was already established in your mind that President Trump was one of the people who could drive the most sales and maximize the most profit for the National Enquirer, right?
Yes.
And so you ran articles about President Trump because it was good for business, correct?
It was good for business.
Pecker also outlined the business reasons for the negative stories about Trump's opponents.
And you were shown some exhibits by the government that related to stories the National Enquirer ran about those 3 men, correct?
That's correct.
There wasn't much new content in those stories, was there?
I would have to reread the stories to answer that question.
We'll take a look at the stories in a minute. But let me ask you this. It was standard operating procedure for the National Enquirer to sort of recycle content from other publications and frame it slightly differently, correct?
Correct.
That's cost effective?
Correct.
Information from the public domain goes into the National Enquirer. It's quick and easy, correct?
Yes.
Good for business?
Yes.
Consistent with your fiduciary obligations, correct?
Yes.
And for at least some of the articles that you testified about on Tuesday, that's exactly what you did, right?
Yes.
There was already negative information in the public domain about Ben Carson, and so you ran it in the National Enquirer, right?
Yes.
And because that was quick and efficient and cost-effective, you would have done that whether or not you had discussed it with President Trump, correct?
Yes.
So you see that there's an article. The top article on this page relates to some kind of issue with a surgery performed by Dr. Carson, right?
Yes.
And in this time frame, 2015, you were leading AMI, right?
Yes.
And you were familiar with what was going on with other publications, correct?
Yes.
You had to be, right, in order to do your job?
Yes.
And you had to be on top of what was in the public domain at the time, correct?
Yes.
You had to keep track of current events, right?
Yes.
So you knew, did you not, that in May 2015, The Guardian published an article regarding several malpractice suits against Dr. Carson, correct?
That's correct.
And so in May 2015, long before any of the articles on this page, The Guardian had covered this issue, right?
Yes.
And in fact, the Guardian article referenced 7 malpractice claims against Dr. Carson, right?
Yes.
That photograph on the top of a child is actually recycled from the Guardian article, correct?
Yes.
And so there are 4 articles on this page that relate to these medical malpractice claims, correct?
Yes.
And all of them contain information that was recycled from a publication months earlier in the Guardian, right?
That's correct.
You see the 4th headline on this page?
Yes.
There's a reference to military service?
Yes.
And do you recall this is also a situation where the National Enquirer posted information that was already in the public domain? Do you recall 5 days earlier, Politico ran a headline, exclusive, Carson claimed West Point scholarship but never applied?
Yes.
And these articles are also based on information that was not exclusive to the National Enquirer, correct?
Yes.
The top article actually refers to a book that had been published about Mr. Rubio, correct?
Correct.
So it wasn't new information published, correct?
That's correct.
Substantially, everything in the exhibits you were shown in 153A, 153B, and 153C, what was going on was the National Enquirer was recycling information from other publications because it was cost-effective and made business sense.
Objection.
Overruled. You can answer.
Yes.
They ran positive stories about Trump, since that was popular with their readers, and the negative stories were mostly just recycling from other news organizations. The prosecution claim that there's a problem with Trump working with AMI to protect his image and help his campaign. But this is something that Trump had done with AMI long before he was running for president.
Now, 1998 was one of the first times that you gave President Trump a heads up about a potentially negative story, correct?
Yes.
Just before you took over at the National Enquirer?
Yes.
And this was a story relating to Marla Maples, right?
Yes.
And you tried to stop the story from running, correct?
Yes.
And you tried but failed?
Yes.
It ran?
Yes.
But this was the first time that you made that effort to reach out to President Trump about a story and to prevent it?
Yes.
And that's almost 17 years prior to the meeting that you described in August of 2015, right?
That's correct.
So 17 years of providing President Trump with a heads up about potentially negative publicity, correct?
That's correct.
Fair to say that predated that meeting at Trump Tower in August 2015 by a long time?
Yes.
It was a lot of interactions, correct?
Yes.
And several stories, right?
Yes.
In addition to Trump Style, you also used the National Enquirer to run positive stories about President Trump, right?
Yes, I did.
Again, long before 2015, correct?
Yes.
And because that was good for business, right?
Yes.
And this sort of took off, this idea of using the National Enquirer to promote President Trump because it was good for you around the time of The Apprentice, the first show?
That's correct.
And this is in the early 2000s, correct?
Yes.
And I think you said on Tuesday by that time, early, you and President Trump had a mutually beneficial relationship, correct?
That is correct.
In addition to a friendship?
Yes.
And on the mutually beneficial relationship side of things, President Trump was giving you content to run in the National Enquirer, correct?
Yes.
And that included information about ratings relating to The Apprentice?
That's correct.
And what was going on with the show?
Yes.
Access to participants on The Apprentice, right?
Yes.
And that helped you, correct?
Yes, it did.
And in exchange for that, as part of this friendship, you also continued to provide President Trump with information about potentially negative stories?
Yes.
And you also promoted some of President Trump's positive stories, correct?
I did.
Before this investigation started, you had not heard the phrase catch and kill, correct?
That's correct.
Never heard of it?
That's right.
The first time you heard that phrase was from a prosecutor, right?
That's correct.
This relationship that you had with President Trump, this mutually beneficial relationship, you had similar relationships with other people, right?
I did.
Meaning that there were other people for which you would provide a heads up if there was a potentially negative story, correct?
Yes.
And other people that you would promote in the National Enquirer because it was good for you and it was good for them, right?
Yes.
And that included celebrities, right?
Yes.
And most celebrities want positive treatment in all publications, right?
They do.
And you also had relationships like this with other politicians, correct?
Yes.
And you are aware that many politicians worked with the media to try and promote their image, right?
Yes.
And to promote their brand, correct?
Yes.
To facilitate their campaigns, correct?
Yes.
Standard operating procedure as you understand it.
Yes.
And then sometimes when the politicians are doing that, that is to try and win elections, right?
Yes.
Nothing surprising about that, is there?
No.
And that's your personal experience, correct?
Yes.
And you are also aware from your decades of experience, right?
Yes.
That includes even presidential candidates, correct?
Yes.
Long before 2016, right?
That's correct.
Cohen had also worked on Trump's behalf with Pecker to protect Trump's image long before the supposed conspiracy.
President Trump introduced you to Michael Cohen around 2007, I think you said?
Yes.
And at that time, President Trump told you that Cohen was his personal lawyer, right?
That's correct.
And that's the only job that you knew Cohen was doing for President Trump, right? Personal lawyer?
Yes.
He became sort of an intermediary to help you provide information to President Trump about potentially negative stories, right?
Yes.
And also when there were situations where President Trump could be promoted in the National Enquirer, right?
Yes.
You started to work with President Trump's personal attorney, Michael Cohen, on those issues, correct?
Yes.
For at least 8 years prior to the August 2015 meeting, right?
Yes.
And in 2015 and 2016, Cohen was always clear with you that he was not working for the campaign, correct?
Yes.
All of this is very important because one of the sets of illegal means of the conspiracy that the prosecution put forward is a violation of election law through large in-kind donations. One defense against this is to show that the in-kind donations would have happened even if the candidate wasn't running for office. So, before Trump ran for president, AMI published positive stories about him and alerted him about any negative stories in the marketplace. And after he started running, they continued doing the exact same thing. However, now it is supposedly a conspiracy and illegal. There were also other examples of politicians who had worked with AMI to help their campaigns. In fact, when Arnold Schwarzenegger was running for the governor of California, AMI did even more to help him than they did Trump.
And you testified today about having done something similar for Arnold Schwarzenegger, correct?
I did.
Around the time that he was running for the governor of California, right?
Yes.
That was in 2003?
Yes.
And in that period, were you trying to acquire AMI's holding into the fitness phase, right?
I did.
To move forward with this giant acquisition, you needed Arnold's blessing, correct?
Yes.
And so you went and met Arnold personally?
I did.
And you reached an agreement?
Yes, we did.
And at the time of this agreement, he had not yet announced his candidacy to become the governor of California, right?
That's correct.
And so one aspect of the agreement was that Mr. Schwarzenegger did not want any more negative stories written about him in your magazines, right?
Yes.
And I think you said this morning that he had expressed some concerns with you that in the past, the National Enquirer had run some pieces that he didn't like.
Yes.
And you agreed, did you not, to make that happen? To stop running negative stories about Arnold Schwarzenegger?
I did.
And Mr. Schwarzenegger also asked for help because he thought that there were a number of women that were going to come out and make accusations once he announced his campaign. Is that correct?
Yes.
And you agreed to help him with that, correct?
I did.
And in addition to that, Mr. Schwarzenegger, we give an equity in AMI, correct?
Yes.
So 50 million in equity on a 365 million acquisition, right?
Well, it was equity of the whole company.
It's a significant amount relative to the size of the deal.
Yes.
And then he announced his candidacy, correct?
Yes.
And I think you've said before that at that time, women started coming out of the woodwork, right?
That's correct.
And so this morning you mentioned one story that you purchased for Arnold Schwarzenegger, correct?
Yes.
Purchased in 2003, right?
Yes.
But in fact, 30 or 40 women came to you and AMI was following that. The announcement of his candidacy, correct?
Yes.
And you spent almost $1 million purchasing the rights to those stories, correct?
I didn't think it was that high.
Several $100,000?
It was hundreds of thousands of dollars.
And Mr. Schwarzenegger never paid you back for that, correct?
No, he did not.
Now, I think that the one story that you described purchasing this morning, was it the source of that? Was Gigi Goyette?
Yes.
And you bought the rights to a book that she wanted to publish about her relationship with Mr. Schwarzenegger, correct?
That's correct.
And you actually, during the candidacy, sent reporters to Ms. Goyette to bring her to Hawaii to get her away from California so that Mr. Schwarzenegger could campaigns, correct?
I did.
And at some point there was some backlash over this, correct?
Yes.
And that happened when you were investigated about an FEC's disclosure relating to the equity interest granted to Mr. Schwarzenegger, right?
That's correct.
And I think you testified this morning that there was an investigation in California?
Yes.
There were no findings against AMI in connection with that investigation, correct?
No.
And as a result, there was also an internal investigation at AMI, correct?
Yes.
And I don't want to get into what you said to your attorneys or not, but as a result of that investigation, you and AMI decided to implement new policies and procedures around this type of issue with assisting a campaign like Mr. Schwarzenegger's, right?
Yes.
And you did that, right? You implemented policies and procedures?
We did.
And you followed them, correct?
I did.
Followed them, including in connection with the events you described in 2015, 2016, and 2017, correct?
I thought I did.
You thought you did?
Yes.
Pecker also didn't just catch and kill stories for campaigns. He testified about buying stories for other celebrities too.
You have also purchased a story relating to Tiger Woods, right?
We didn't purchase, I should say yes, it was a source agreement, so we did purchase it, yes.
And you purchased some photographs, right?
We purchased a story about Tiger Woods from a source, but all the investigating photographs, all the investigative works was done internally.
And the photographs that we're talking about are photographs of a woman meeting with Tiger Woods at a parking lot in Florida, right?
That's correct.
And this is one of those instances where you bought the rights to a story in order to leverage it against a celebrity, correct?
Yes.
To use the access that you had to this information and the exclusive rights that you had to get Tiger Woods to do something that you wanted?
Yes.
And in this instance, and this is around 2007, correct?
That's correct.
And in that instance, what you wanted was for Mr. Woods to appear on the cover of Men's Health, right?
It was Men's Fitness.
Thank you, Men's Fitness, and you also wanted him to do an interview, correct?
Yes.
And at the time, Mr. Woods, if not locked up exclusively, he had a relationship with Condé Nast, right?
The answer is yes. And he also had an exclusive with, I think it was Golf Illustrated.
So he needed some convincing to sit down with AMI, right?
Yes.
And so you bought the rights to these photographs, correct?
Yes.
And at the time that you bought the photographs, you had no intention of running the story, correct?
No, I wasn't going to run it. The purpose of buying the story...
Oh, I'm sorry, excuse me. The purpose of buying the photographs was to leverage them against Tiger Woods to get him in the magazine, right?
Yes.
So there was nothing unusual about AMI's relationship with Trump. They treated him exactly like any other celebrity that was helping them sell copies of the National Enquirer. The idea of a conspiracy gets more ridiculous when we look at the case of doorman Dino Sajuden. AMI bought Sajuden's story of Trump fathering an illegitimate child with a maid. They investigated it internally and found that it was false. The deal that AMI arranged was completely standard and identical to any other contract they would negotiate with any other source. It wasn't until much later that Pecker amended this deal to be in perpetuity. This was because Dino was threatening to go to AMI's competitors, and at the time, Pecker thought the story might still be true. On cross-examination, the defense even got Pecker to admit something, which completely destroys the catch and kill narrative.
And you believe that if this story was true, it was worth a lot of money, right?
Yes.
What I'm asking about now is what was in your mind in 2015 as this was happening, okay?
I understand.
So, when it was reported to you that somebody was saying the things that Mr. Sajuden was saying, you believed that if those were true, it could be the biggest National Enquirer article ever?
That is correct.
And I think you testified about the Enquirer's coverage of Elvis Presley's death, right?
Yes.
Think, if I'm recollecting correctly, there were about 6.5 million sales associated with the National Enquirer's coverage of that death.
That is correct.
And you thought that if this story was true, Mr. Sajuden's claim was true, that it could sell 10 million National Enquirers, right?
I did.
So, if this story was true, you were going to run it, correct?
Yes.
Because you had a fiduciary obligation to do that, right?
That is correct.
It would have made business sense, to put it mildly, to run such an article if it was true, correct?
Yes.
And as soon as you heard the story about Mr. Sajuden, you knew that to be the case, right?
I did.
So not really a great conspiracy. Trump, Cohen, and Pecker conspire to catch and kill negative stories about Trump, but the first time a negative story comes up, Pecker would have published it and sold 10 million newspapers. That story, if true, would, if not completely kill Trump's campaign, seriously hurt it. And Pecker would have put it on every newsstand in America. Furthermore, Pecker even literally said that he never discussed a Sajuden deal with Trump, and that Trump never paid him for the Sajuden deal. So even if the deal is illegal, Pecker doesn't connect it to Trump at all. Next, we move on to the McDougal deal. Just like the previous contract, this deal was completely lawful on its face. There is nothing illegal about purchasing someone's life rights. Also, purchasing this story didn't actually influence the election. For the purchase to have made a difference, there would have to have been a different effect if the story wasn't bought by AMI. But that wasn't the case here. Davidson admitted on direct that McDougal wasn't actually looking to publish her story. He also elaborated on this on cross-examination.
Ms. McDougal did not want to publish an article about the claims that have been discussed here, right?
True.
And I think you said on Tuesday that she had 3 goals, right?
Yes.
One goal was to rejuvenate her career, right?
True.
That directly transitions into the defense's next point. McDougal wanted to get back into the fitness industry, and it worked. As part of the deal, McDougal was put on 2 AMI Fitness magazine covers and wrote 20 articles. According to Cohen, Pecker said that there was no need to pay AMI back for the McDougal deal, since they made so much money from signing McDougal that it was a good business investment. Cohen was under the impression that the men's fitness cover featuring McDougal sold more copies than any previous edition of the magazine. So if the McDougal deal was lawful, and both sides got from the deal what they wanted, McDougal got her career renewed, and AMI sold tons of magazines. And even if the deal hadn't happened, the story would not have been released. Then how could this possibly be a catch and kill deal that influenced the election? Now we get to the planned transfer of McDougal's life rights from AMI to Trump. The biggest thing to deal with here is the tape. The tape supposedly records a conversation between Cohen and Trump. I played it in part 1, and I very intentionally didn't include the transcript that was put forward by the prosecution. This is because the tape is evidence, but the transcript is not. If the jury hears something on the recording which is different from the transcript, they must use their own interpretation, not the prosecution's, when weighing this evidence. On the tape, Cohen is pretty understandable, but Trump is not very clear, to say the least. This is since Cohen was literally holding the phone in front of him when talking to Trump. So I'm going to play it now, and I will be including the prosecution's transcript on screen. So if you don't want to be biased by that and see what you can hear for yourself, then close your eyes and listen carefully.
I need to open up a company for the transfer of all of that info regarding our friend David, so that I'm going to do that right away. I've actually come up and I've spoken to Alan Weisselberg about how to set the whole thing up with
So what are we going to pay?
funding. Yes, and it's all the stuff. All the stuff, because you never know where that company, you never know where he's going to be. Correct. So I'm all over that, and I spoke to Alan about it when it comes time for the financing, which will be.
Listen, what financing?
We'll have to pay you. So
Don't pay with cash.
No. I got no. Hey Don, how are you?
At the end of the tape, we can hear Cohen saying, "Hey Don, how are you?" Cohen claims that this was him getting another call from somebody named Kathy Battle, which caused the recording to stop. Putting aside how possible that is, the defense looked through all of Cohen's call logs, and they found that this call went straight to voicemail. Neither side released the full call logs, so I can't independently verify this. But if that's true, it certainly puts in question some of the prosecution's strongest evidence. Even if it went to voicemail, but Cohen thought he picked up the call, we also need to ask why he said "Hi Dawn" if he was actually getting a call from Kathy. Another factor to keep in mind is that Trump's assistant Rona Graf's voice can be heard earlier on the tape. It is before the key parts that I've played, but Cohen agreed that it was her voice. Miss Graf was actually the second witness at this trial. The prosecution chose not to ask her any questions about the tape. Maybe she could have verified its authenticity, or told us exactly what Trump said. The prosecution intentionally chose not to ask her any questions about that. Finally, we have the Daniels deal. This should be the last nail in the coffin of the conspiracy. That's for one simple reason. Pecker refuses to buy the story. It's a conspiracy to do catch and kills, except Pecker refuses to catch and kill stories. That's not much of a conspiracy. There's also another problem. There was no story to catch and kill. Daniels had published her interaction with Trump in the Dirty.com in 2011. The story was already public. You can't catch and kill a story which is public. So the prosecution say that there was a conspiracy where Cohen, Pecker, and Trump colluded to use the National Enquirer to influence the election. But the National Enquirer writes the same kind of stories about Trump as they did before. They write stories about his opponents, which are low effort and their readership enjoys. The first chance Pecker gets to catch and kill a story, he admits that if it were true, he would have published it and damaged, if not killed, Trump's campaign. They supposedly catch and kill a story which McDougal wasn't going to publish anyway, coincidentally making a deal with McDougal that sells more editions of Men's Fitness magazine than has ever been sold before. And when Daniels' story comes up for grabs, which, by the way, was already published in 2011, Pecker straight up refuses to buy it. That's not a great conspiracy, if you asked the defense. There's also some other weird details about it that come up, such as that if it is such a super secret conspiracy, when repaying Cohen, why get Eric and Don Jr. to sign the first 2 checks? Especially since Trump signs the rest of the checks. Why not get him to sign them all from the start? Why include Don and Eric in the cover-up of this super secret conspiracy for no reason? Even if we do believe that there was a conspiracy to write positive stories and catch and kill stories which were harmful to Trump, and that illegal means were used to do it, the prosecution still needs to prove that Trump did it with an intent of influencing the election. Trump doesn't need to be running for president to want good stories about him. If nothing else, it's good business. The Trump brand is so strongly tied to him that positive stories about him make his brand more valuable. So if Trump conspired to have positive stories written to promote his brand, even if he used illegal means to do it, that's not a violation of election law, which is a required part of this case. As for the conspiring to catch and kill stories, these were women and Dino Sajuden claiming that he cheated on his wife. You don't have to be running for president to want to cover that up. Trump easily could have conspired to cover up those stories to protect his family. Even if there was a conspiracy and illegal means were used, since Trump was protecting his family and not doing it to help his campaign, he didn't break New York election law. Thus, he's not guilty. The prosecution failed to prove beyond a reasonable doubt that Trump intended to influence the election, and they certainly didn't prove that there was a conspiracy to do it. This wall is weak and Trump is not guilty. The final wall of this case is Trump's intent to have false business documents created. We can take into account evidence from other walls about what Trump said and did, what happened, and what the likely outcome would be based on Trump's actions. That's why we have saved this wall for last, so that we have seen all of the defense's evidence. We can also use prosecution evidence from other walls to prove that Trump didn't have the intent of creating false business records. In fact, some of the prosecution's strongest evidence that Trump knew about the repayment scheme is also the defense's strongest evidence that there was no intent. The prosecution claim that Trump acted with others to create false business records to cover up Cohen getting paid back for buying Daniels' story. If we put ourselves in the mind frame of somebody who is intentionally creating false business documents and paying someone back double to hide the reason for the payment, what are some things that they would not do? Well, they probably wouldn't tweet about reimbursing that person and wouldn't release the information on a government form. Trump, however, tweeted out in a 3-tweet thread that he reimbursed Cohen from his personal funds. He also explicitly says that the reimbursement is for Cohen paying for the NDA with Stormy Daniels. He also included in a footnote of a government ethics form that he is reimbursing Cohen. This disproves intent. the prosecution say that Trump created false documents to hide the payments. Trump clearly didn't care about hiding anything. The prosecution also claims that Trump was motivated to create false records to stop anyone finding out about women's stories about him, especially after the Access Hollywood tape was released. They say that his electoral prospects were seriously hurt by it, and that any new stories would be deadly to Trump's campaign. In reality, the Access Hollywood tape was just another of many negative stories about Trump, which were a huge deal for one day and forgotten the next. Trump knew this at the time. Madeleine Westerhout described Trump's reaction to the tape.
But before the transition, there was the Access Hollywood tape that you were asked about on direct examination, right?
Yes.
And you testified on cross that it rattled the RNC leadership, correct?
That's my recollection, yes.
There were a couple of days of consternation, right?
Yes.
That happened all the time during the campaign, right?
Yeah.
There's always some event that causes total consternation for a couple of days, right?
Yes.
And when President Trump was running for election, there was always some event that everybody said, claps twice, that's it, he's not going to win, right?
Yes.
And everybody around would be freaking out, right?
Yeah.
But not President Trump, right?
No.
He did not freak out about any of this, right?
Not that I was aware of.
He just kept his mind straightforward and kept running for the election, right?
Yes.
Trump wasn't desperate to cover anything up. He literally tweeted about the payment he was supposedly trying to hide. Intent definitely was not proven beyond a reasonable doubt. Wall 3 is not strong enough to convict Trump. So those are the 4 walls. And if, and only if, looking at both sides of the evidence, we find that the prosecution has proven every single one of these beyond a reasonable doubt, can Trump be found guilty. But we can also look at the general lack of evidence to get reasonable doubts. The defense already put forward arguments as to why Cohen is unreliable and should be disregarded. But Pecker has his problems too. Pecker has an agreement with the prosecution that in exchange for his testimony against Trump, he'll be immune from any charges arising from his conduct in this case. But if he lies, the agreement is void. Even if he tells the truth, but the prosecution thinks it is a lie, that is something that they would have to fight out in court. That's certainly a strong motivation to tell the prosecution what they want to hear. Even if they are not big lies, Pecker is motivated to maybe remember things in ways that help the prosecution and fit with their view of what the truth is. Knowing this, can Trump really be found guilty beyond a reasonable doubt on his testimony? The final reasonable doubt the defense put forward has nothing to do with the exhibits or the testimony in this case. They relate to the testimony that wasn't in this trial. Alan Weisselberg was Trump's second in command at the Trump Organization. The prosecution claim that he was intimately involved alongside Trump in the plot to secretly pay Cohen back. Weisselberg didn't testify in this case. Keith Schiller was Trump's bodyguard. He was supposedly a middleman through whom people could reach Trump when he was on the campaign trail. Through him, Cohen and Pecker spoke to Trump, allegedly illegally conspiring to influence the election. Maybe Schiller knows something. Maybe he doesn't. We don't know because the prosecution didn't call him. Gina Rodriguez was Daniels' agent. She played a huge part in negotiating the NDA alongside Davidson. We have no idea what she would say on the stand since she wasn't called by the prosecution. Eric Trump and Donald Trump Jr. literally signed 2 of the checks Trump is being prosecuted for. What was their knowledge about everything? We don't know because the prosecution didn't call them. And finally, we have Dylan Howard. Howard is basically the 4th honorary member of the conspiracy between Pecker, Cohen, and Trump. Howard did more than Pecker on a day-to-day basis when it comes to helping Trump for AMI. He was the key man that negotiated all 3 of the catch and kill deals. Now, Howard was not called since he couldn't travel from Australia due to health reasons. But that doesn't matter. We can't just say, well, the prosecution has a sick note, so I guess we'll just find Trump guilty. It is the prosecution's obligation to bring evidence to prove it beyond a reasonable doubt. If some of that evidence is missing, it doesn't matter why. It has to be not guilty. So that's the defense's arguments as to why Trump is not guilty. Do you think they did a good job? Did they raise reasonable doubt in your mind? Or is there enough evidence the prosecution put forward in part 1, which the defense failed to refute? But remember, this isn't the end. This whole video was from the defense's perspective, putting forward their arguments. But the prosecution still has one more chance to respond. And we will see how they do that in part 3 of this series. The prosecution presented their evidence, the defense attacked it, and now, in part 3, the prosecution gets to finish the case by defending against those attacks. This is the 3rd part in the series. You should probably watch the other 2 parts first. Anyway, let's get right into it. We are going to jump right into the first wall. Here, the prosecution produced evidence that the information in the documents is factually false, and the defense says that the information is true. The defense claim that it is accurate that Cohen was paid for work he was doing as personal attorney to the president, and that they had at least an oral retainer agreement, making the payments illegal. We will deal with those one at a time, starting with the amount of work that Cohen did. Cohen readily admitted on cross-examination that in 2017 he did do some work for Trump. That work included finding other lawyers to represent Trump on specific matters, threatening to sue journalists for Trump, and helping the First Lady on a trademark issue and the licensing of her image for a wax statue. But at the end of the day, he still estimates that the total amount of time spent on all of that was less than 10 hours. One very consistent theme the prosecution often touched on throughout this case is Trump's frugality. Some examples of that were included previously, but suffice to say that it's not unimaginable that a juror would come away with the impression that Trump was a penny pincher. Knowing this, it's hard to imagine Trump paying Cohen $420,000 for 10 hours of work. He probably would have either refused to pay or at least negotiated the amount down. But he didn't. That's because Trump knew that Cohen wasn't getting paid for work and the conclusive proof can be found in the final invoice. Cohen sent the invoice at 11 minutes past 9 on the 1st of December. There is no possible way that Cohen did $35,000 of work in 11 minutes. Trump would not have looked at the invoice dated December 1st and said, "Wow, Michael sure did enough work for me in these 11 minutes to pay him $35,000. The $420,000 was not compensation for actual labor that Cohen was doing for Trump. There is clearly something else going on here." Well, maybe Cohen had a retainer. Even if Cohen did no work for Trump, if they had a retainer agreement, Trump would have to pay him anyway. Well, there is no physical retainer agreement, so the defense say that maybe Trump and Cohen had an oral retainer agreement and a plan to officially write it up later. They point to an Alan Weisselberg email where he asks Cohen to send a retainer, and Cohen, when testifying at trial, actually agreed that in the meeting between himself, Trump, and Weisselberg, there was a plan to create a retainer agreement. The prosecution actually agree that this was the plan, but the retainer would have been just another step in reimbursing Cohen. The whole point of paying Cohen as personal attorney to the president was to hide that it was a reimbursement. As Joshua Steinglass said in his closing statements, maybe if they'd actually created a phony retainer agreement, that would have given more cover to their story, but it would just be another false business record, and you would be considering 35 counts instead of 34, because these payments had nothing to do with a retainer agreement and nothing to do with services rendered in 2017. The lack of importance of the retainer agreement is further proven in this case by the fact that after Cohen didn't send a retainer agreement, he was paid anyway. McConney didn't ask to see a retainer agreement when he got sent the first invoice. Weisselberg didn't ask to see a retainer when he approved that payment. And Trump didn't call the office from the White House when he signed the checks, which specified they were for a retainer. Why not? Because all three knew that Cohen isn't actually getting paid pursuant to a retainer. He is being reimbursed for the Daniels deal. The retainer is just a red herring put forward by the defense. But there is actually one more key fact which completely disproves the idea that Cohen was paid for work or a retainer. Cohen was the personal attorney to the president for 15 months, from the start of 2017 until April 2018. But he was only paid for the 12 months in 2017. If they had a retainer, he would have been paid for the 3 months in 2018 too. If he was being paid for the work he was doing, he definitely would have been paid in 2018. He was fighting to enforce the NDA against Stormy Daniels after she started going public. But he wasn't paid at all in 2018. So he was the personal attorney for 15 months, but he was only paid for 12. And it just so happens that he was paid the exact amount of $420,000, split evenly into 12 monthly checks. And when we look at exhibits 35 and 36, it says that Trump is reimbursing Cohen exactly $420,000, split into 12 monthly checks. That's proof beyond a reasonable doubt. But there's more. We also have testimony that it was a reimbursement. Cohen said it was, and Pecker and Davidson both testified that Cohen told them he expected to be reimbursed. Cohen told them that, long before his falling out with Trump, by the way. And finally, we have the most damning third-party account. That's Jeffrey McConney. He worked for Trump for over 30 years and made it all the way to Senior Vice President Controller. He likes Trump. He has no reason to lie. And he said that Alan Weisselberg, Trump's second in command, came to him and told him that they were reimbursing Cohen. Weisselberg broke down the components of the repayment and outlined why they were paying Cohen double. Why did Weisselberg give all these details? He didn't do that for the other accountants, like Deborah Tarasoff. He did it for McConney because he trusted McConney. And McConney, who had no reason to lie, said it was a reimbursement. There's a paper trail too. We have McConney's notes from the meeting, and also the same content in Weisselberg's handwriting. And McConney, who is very familiar with Weisselberg's handwriting, attested that it's his handwriting. And it's a good thing that we have these documents too. If it weren't for them, it would just be a he said, she said. On one side, we have Donald Trump through his lawyers in court saying it was a payment for work. And on the other side, we have also Donald Trump saying it was a reimbursement. And these last few facts completely kill any chance that these 34 documents are accurate. We have Trump's filings in a civil lawsuit with Daniels saying it was a reimbursement. We have Trump including in a government ethics form that it was a reimbursement. And Trump willingly tweeted out it was a reimbursement. He even says that Cohen was given a retainer as part of the repayment. Cohen was not paid for services rendered pursuant to a retainer. This wall is proven beyond a reasonable doubt. Previously, the defense tried to discredit Michael Cohen and convince us that we should disregard his testimony. In a vacuum, they did a relatively good job, but the prosecution have some additional context to add. The defense talked about how large the payment Cohen made to Daniels was, and also commented on his ability to afford it. They contrasted him saying that it was very substantial and that he would not have made it without the expectation of getting paid back, with an audio tape where he and Davidson are talking about how the payment isn't that big. There is some key missing context though. That call is in relation to the bank flagging the wire transfer and asking Davidson questions about it. Cohen and Davidson aren't saying, "Oh, who cares? It's just $130,000. Cohen was rich, but it's not like he's just going to let a massive payment like that go. He testified about the huge shitstorm he caused when his bonus was cut, and the amount that it was cut by is actually less than the Daniels payment. What they are wondering about on the call is why the bank is analysing the transaction, and they agree that it's not because of its size. That's true. A massive corporate bank doesn't call up all of their customers every time they have a transfer of $130,000. They must have done it for a different reason, and Cohen and Davidson are starting to suspect that some law enforcement agency was asking the bank questions, which, by the way, they were. Another apparent inconsistency is related to a call Cohen placed in October. On direct, Cohen said that he updated Trump on the Stormy Daniels deal. However, the defense found evidence that he was discussing prank calls with Trump's bodyguard. He spoke with Keith Schiller for 1.5 minutes about a teenager threatening him over the phone. However, that doesn't mean that he's lying. The defense stipulated that Schiller and Trump were together during the time of the call, and there's enough time to briefly discuss the prank calls and then have the phone pass to Trump and update him on the Daniels deal. And even if it didn't happen on that call, Cohen could just be misremembering which exact date he updated Trump on. Cohen consistently updated Trump about the deal, so maybe he just saw that call record and assumed that it was the call where he gave Trump a specific update. Cohen can be wrong without lying, and being wrong on one insignificant fact shouldn't cause the jury to disregard somebody's whole testimony. Let's move on to the position in the White House. The defense says that Cohen was mad at Trump for not getting a role in his administration. It is true that at one point Cohen said it would be nice to be chief of staff, but after he didn't get that job, he was immediately gunning for something akin to the personal attorney to the president. We can see that in the text to his daughter after Reince Priebus became the chief of staff. When talking about roles that were still available, Cohen brings up a hybrid role. This is important, but to understand its significance, we need to learn why Cohen wanted to be personal attorney to the president in the first place. Was it for the prestige of the title, or just a handy way to hide the reimbursement? Maybe in part, but the main goal was to get paid as a consultant by the private sector. When Trump became president, companies didn't know what his policies would be or what he would do. So Cohen was the inside source who would use his years of experience working with Trump to advise those companies. And the title of personal attorney to the president was a great way of showing his credibility. In 2017, he made approximately $4 million from consulting contracts with 6 clients. So maybe Cohen did want to be chief of staff, but that, frankly, was always a bit of a long shot. And Cohen was certainly satisfied with the $4 million payday he got as a consolation prize. He didn't flip against Trump after he missed out on becoming chief of staff, and he wasn't lying when he said he was satisfied with his hybrid position. Another reason that the defense says Cohen's testimony should be disregarded is due to a number of lies that he admits to telling previously. But Cohen is pretty upfront about that. He admits that he used to lie for Trump, scheme for Trump, and threaten legal action for Trump. And the defense say that this kind of person shouldn't be trusted on the witness stand. To a certain extent, that's true. Somebody with Cohen's history is not the kind of person that the prosecution would want as a vital witness in their case. But the prosecution didn't just decide to choose him to be their star witness. Donald Trump chose him, and the exact same qualities that the defense are saying are bad and count as a reason Cohen should be disbelieved are the exact same qualities that are the reason that Trump hired him in the first place. Trump didn't want another by-the-books lawyer. He had plenty of those. He wanted a fixer who would threaten to sue anyone who spoke badly about him, who would help Trump underpay his contractors, and who would lie for him. When Cohen lied to his wife and his bankers about the Daniels payment, it was to help Trump. When Cohen lied to reporters, it was to protect Trump. When Cohen lied to prosecutors and the FEC, it was at least in part to protect Trump. And when Cohen lied to Congress and the Senate about Trump Organization business connections to Russia, he did it to protect Trump. If Trump gets to benefit from Cohen's lies for years, he should also be hindered by Cohen telling the truth on the witness stand. Also, if Cohen was going to lie, he would have told more extravagant lies. He could have said that he, as a legal professional, explicitly advised Trump that the catch and kill conspiracy with Pecker was a violation of campaign law. He could have said that he went through every detail of the catch and kill contracts with Trump, and he could have said that Trump personally planned every aspect of the repayment scheme. But he didn't, because that wasn't true, and Cohen told the truth to the best of his recollection, and his recollection largely matches the testimony of other witnesses and the physical evidence. The defense would say, well, of course his testimony matches the others. He admitted to following the trial before testifying. Well, sort of. We heard his exact testimony previously, but this line of thought is missing a key fact. It is true that Cohen was one of the last to testify at the trial, but Cohen didn't tell his story for the first time in May 2024. He pled guilty to charges related to this case in August 2018, and he gave the prosecutors his story then. So, unless Cohen has a time machine, there is no way that his account was influenced by 2024 trial testimony. And this brings us to our final point for Cohen. Cohen did plead guilty to falsifying business documents and illegal campaign contributions. And while he did serve his time and has gotten no decrease in his sentence for his testimony in this case, he is still a co-conspirator, which means his word alone cannot be used to find Trump guilty. But his testimony can be taken into account if there is other evidence that connects Trump to the crime, or there is evidence that harmonizes with Cohen's account. And my God, there's a lot of that kind of evidence. So far, we have stuck to the trial testimony and the most important exhibits. And I'm sure that many of you have been wondering when all of the text and phone records were going to come up. Well, it's right now. So let's quickly go through the narrative again, and this time include the physical evidence. We are selecting the 12 months, which includes all of the key events that we have covered in this series. We will also be focusing mostly on the key days when important events happened. And just to be clear, a call log looks like this, with the first name being the person making the call and the receiver being the second name. The duration of the call is in the second last column, and we have two time columns. One is Eastern Standard Time, which is the time a call occurs for a participant on the east coast of the US. The second time column is UTC time, which is basically the time in London and is an international standard. The texts will also be denominated in UTC time, so the order of events will be matched based on that. A text log looks like this, with the actual content of the text being at the bottom of this column here. Then, we also have emails and other exhibits. The Signal app was also used, but there are no logs of any kind for the vast majority of that. So the meeting between Cohen, Trump, and Pecker, where the conspiracy started, was in August 2015, but we will be starting in November. AMI are approached by Dino Sajuden, and they pass the story on to Cohen, who runs it up to Trump. Trump asks Cohen to handle it and make sure that the story doesn't get out. The Sajuden deal was signed on the 15th. Howard, Cohen, and Pecker were actually pretty good about using only the Signal app during this time. so we don't actually have many phone or text logs. But we will see the conspirators get sloppy later. At some point between then and mid-December, Cohen requests changes to the deal, altering it to be in perpetuity and adding a damages clause. 2 days after that is executed, Howard emails Cohen to confirm the changes have been made, which pleases Trump greatly. In January of 2016, we just have one quick item. Cohen and Pecker said that Cohen would suggest stories and approve articles for AMI. Here, we have an email where AMI sends Cohen some positive articles about Trump, and he then suggests some changes. Those articles went on to be published in the National Enquirer. And our final stop, before we get to the McDougal deal, is in April. This is that time that Stormy Daniels' agent, Gina Rodriguez, tried to sell the story of the Daniels affair to AMI. But nobody cared, because this was long before the Access Hollywood tape was released. So they basically just ignored her. Now we get to June. So Davidson texts Howard about a blockbuster deal. This is the McDougal affair, by the way. And Howard tries to find out from Davidson if Trump is cheating on Melania. But Davidson won't disclose any details this early on. Howard again informs Cohen, and Trump again instructs to stop it from coming out. A couple of days later, Davidson emailed McDougal a retainer agreement. On the 16th of June, Howard and Davidson organize a meeting for the following Monday where they will discuss the details of the deal. Howard informs Cohen about this, who then calls Trump and lets him know. Cohen continues to pester Pecker and Howard for any updates for the next couple of days leading up to the meeting. On the day, Howard flies out to LA and has the meeting. The whole time, Cohen is constantly trying to call him and call Pecker to get any updates to pass on to Trump. After the meeting, a three-way signal call occurs between Cohen, Pecker, and Howard. They are unsure if they need to buy the McDougal story since there is no physical proof. We don't actually have the signal call since Signal does not store call logs, but we do have Howard organizing the call with his assistant. That evening, after some more calls, Howard tells Davidson that they are still immovable from his end. Davidson locates McDougal's old BlackBerry, hoping to find proof of the relationship on it. At some point shortly thereafter, Trump has a call with Pecker, where Pecker recommends that Trump buy the story. Later, Cohen calls Pecker back and tells him to go ahead with the purchase of the story. He says the boss will take care of it. Pecker then authorizes Howard to start negotiating the details of the agreement. Towards the end of June, Gina Rodriguez again approaches Howard about selling the Stormy Daniels story. Unlike how Davidson did for McDougal, she discloses a large amount of the story from the start. But once again, there is no particular urgency from Howard and the rest of the conspirators to cover up the Daniels affair. Anyway, Howard negotiates the McDougal deal with Davidson for about a month, and it's not going too well. By mid-July, McDougal is actually more likely to accept an ABC deal that would involve her telling her story in exchange for a spot on Dancing with the Stars. Davidson conveys this to Howard to spur an improvement in AMI's offer. They have a meeting on the 21st of July, but it isn't until the 23rd that they get around to negotiating a final price. A week later, McDougal finally rejects AMI's offer. Howard informs Cohen, and a plan is conceived for AMI to have another meeting with McDougal to convince her to take the deal. In that meeting, the sides agree to a price of $125,000. Shortly thereafter, Davidson notifies Howard that McDougal has reneged on that sum and now wants $150,000. Howard replies, "F it, not my money," and immediately calls Cohen. After a brief amount of time, Howard calls Davidson back to accept the new amount. 3 days later, the deal is meant to close, but the final agreement that AMI sends to McDougal is very different than what was agreed to at the meeting. They managed to sort it out, and AMI's lawyers encouraged Davidson to call Cohen as a courtesy. But Davidson is trying to avoid that because from prior experience, Cohen is really difficult to work with. In the end, they do have a call, and Davidson tells Cohen that this deal would not have happened without Dylan Howard's help. The next day, the deal is signed with payment to occur a couple of days later, thus concluding the McDougal deal. In September, Pecker has a lunch meeting with Cohen where he asks to get paid back for the McDougal transaction. This needed to happen before September 30th, as this was the end of the financial quarter and the purchase of the McDougal story would be identified as suspicious if the discrepancy was not fixed in AMI's books. They negotiate this reimbursement, but Pecker was under the impression that Cohen was either stringing him along, or perhaps Cohen wanted to pay, but Trump didn't. That would result in Pecker not being reimbursed, since Cohen couldn't even pay for his lunch without Trump's approval. So on the 10th, Cohen records a conversation with Trump where they discuss paying Pecker back, but he actually doesn't even end up sending it to Pecker. An AMI employee completes the contract in late September, and the day before the deal is finally going to be signed, Cohen calls Trump and updates him on everything regarding the transfer. The contract was signed on the 30th, and Cohen begins to set up the fake company Resolution Consultants to send the money to Pecker's shell company, Investor Advisory Services. In the end, Pecker decides not to go through with the deal and tells Cohen to just rip up the assignment agreement. Now we are getting into October, where the election is really starting to heat up. On the 7th, Trump's Director of Communications, Hope Hicks, receives an email from the Washington Post asking her for the campaign's comment on a recording that would come to be known as the Access Hollywood tape. Cohen is in London at this time, that's why his timestamps are a bit off. The next day, the story is released, and the fallout becomes apparent. Chris Cuomo is texting Cohen, basically saying that Trump's campaign will be dead soon. Gina Rodriguez takes the opportunity to once again pitch the Daniels story to AMI. This time, there is much more enthusiasm from AMI and Trump's end. The story jumps up and down the conspiracy chain for a bit before reaching Donald Trump, and they finally settle with Rodriguez on a price of $120,000. Howard tells Pecker, who promptly informs him that he is not going to pay. So they agree to go to Cohen, who acquiesces to distributing that amount. Rodriguez then approaches Keith Davidson to finish what she calls the easiest deal of his life. It was all already negotiated. All that he had to do was paper the deal and talk to Michael Cohen. With Davidson's cut, the deal went up to $130,000, since Davidson charged $10,000 for having to talk to Cohen and writing the agreement. So the deal is basically completely negotiated, and Davidson sends the contract to Cohen. But Cohen speaks to Trump, and Trump tells him not to pay it. The goal is to push it past the election, since he didn't care if the story came out then. So Cohen is basically stalling and making up excuses to delay. This included saying that the office is closed due to Yom Kippur, and also just ignoring Davidson's emails and calls. But Cohen knows that he probably will need to pay, so he sets up a bank account for his shell company Resolution Consultants. On the 17th, Davidson finally sets a hard deadline. Cohen fails to pay, and Howard needs to intervene to try and get the deal back on track. Cohen also realizes that the name of his shell company, Resolution Consultants, is actually identical to one of his friend's companies. So he decides to open a new company, Essential Consultants. By the way, Cohen ended up pleading guilty to felony charges for creating false business documents for both Essential and Resolution Consultants. So in other words, he committed a felony to change the name of a company that was literally just meant to be used for this one transaction and nobody was meant to find out about. Anyway, Cohen somehow manages to keep the deal in some kind of a limbo until the 25th. That day, Pecker, Howard, and Cohen have a three-way call where Howard criticizes Cohen for potentially ruining his relationship with two of his sources. Pecker also tells Cohen that he should do the deal given the risk to the campaign. At this point, Cohen has managed to get Trump's approval to pay the funds. Trump tells Cohen to go to Weisselberg and sort it out. Weisselberg and Cohen tried to find any way to pay the deal, but all their suggestions come back to Trump. Cohen then suggests that Weisselberg should pay it personally and that Trump would reimburse him. Weisselberg, who is making over $1 million a year from the Trump organization, responds that he needs to send his grandkids to summer camp, so he can't afford it. Thus, they reach the conclusion that Cohen will pay. The next day, Cohen calls Trump in the morning to get the final approval for the deal. He then walks across the street to his bank and funds the account from a home equity line of credit. He then sends Davidson a bank statement, and Davidson is finally convinced that Cohen will in fact pay. The next day, Cohen wires Davidson the money, and the deal is fully signed and complete on the 28th. The following month, Trump won the election, and in December, Cohen had his outburst about his bonus being cut, which led to the meetings with Weisselberg and Trump in January 2017, where the repayment scheme was conceived. Now, at the trial, Cohen, Pecker, and Davidson went through that account in much more detail. Suffice to say, there's a huge amount of physical evidence supporting Cohen's account. There's a huge amount of evidence supporting Pecker's account, and there is a huge amount of physical evidence supporting Davidson's account. Their three stories also match each other pretty closely. The idea that all three of them would fabricate their stories, and it just so happens that they match each other and all of the physical evidence, is preposterous. The only conclusion that one can draw is that the events described actually happened. With that, we are going to move to Wall 4. The defense put a lot of effort into undermining this wall. However, a deeper look into the facts will show that it was proven beyond a reasonable doubt. The defense claimed that Trump's relationship with AMI predated his campaign, so the help that Pecker provided him would have happened even if he wasn't running for president. To be fair, it is true that in exchange for access to participants on The Apprentice, AMI would give Trump a heads up on negative stories in the marketplace, and they also wrote positive stories about him. But this is in a completely different league than what they did as part of the conspiracy. AMI wrote negative stories about Trump's opponents based on information he provided. They basically gave Cohen editor's rights, letting him make alterations to articles before publishing them. They sought out stories and spent money specifically to stop them from being published. They didn't do that to leverage the stories against Trump like they did for Tiger Woods. They did it purely to help him. They were also willing to pay way more for the catch and kill stories because they were helping the campaign. Pecker never would have paid $30,000 for exclusivity rights to an untrue story if it was not his goal to help Trump's campaign. The defense also argued that what AMI did for Trump was normal and legal because they similarly helped Arnold Schwarzenegger for his campaign. That's illogical. What they did for Schwarzenegger was crazy, and also what they did for Trump was crazy. And just because the FEC in California decided that they couldn't prove AMI's guilt beyond a reasonable doubt, doesn't mean that it was legal. And it certainly doesn't mean that what they did for Trump years later was legal. If nothing else, the fact that AMI were even investigated in California shows that what they were doing for campaigns was not normal. There were also some differences between what they did for Schwarzenegger and what they did for Trump.
And you testified on cross-examination that Arnold Schwarzenegger announced his candidacy for governor, and after he announced his candidacy for governor, 30 or 40 women came forward with allegations of sexual harassment. Is that right?
Yes.
And that you told Mr. Bove that you paid hundreds of thousands of dollars to kill those stories?
That's correct.
I don't want to make you do the math on the spot here, but what was the approximate average of those payments?
The largest one was $20,000. Then the other ones would be anywhere from $500 to $2,000.
Did you spend anything like the $150,000 to suppress any story in connection with the Arnold Schwarzenegger campaign?
No.
I believe you also testified that Arnold Schwarzenegger was the frontman for some of your fitness line magazines. Is that right?
That's correct.
Why did you spend money? And when I say you, I mean AMI. Why did AMI spend money to silence Mr. Schwarzenegger's accusers?
Mr. Schwarzenegger was critical to the bodybuilding industry, as well as the supplement industry, as well as the two leading publications, Us, Muscle Fitness and Flex, that we just acquired in the Wider acquisition.
So do I understand that to mean that you were, at least in part, motivated by your desire to protect your own brand value?
It was mutually beneficial.
Your arrangement with Mr. Schwarzenegger?
Yes.
When you say mutually beneficial, it also benefited Mr. Schwarzenegger?
Yes, it did.
To the extent it benefited Mr. Schwarzenegger's campaign, that sparked an investigation into potential campaign finance violations by AMI, is that correct?
Yes.
And as a result of that, I believe you testified when Mr. Bove asked you questions. You made some new rules to address these concerns, correct?
Yes.
Now, when you withdrawn, prior to your arrangements with Mr. Trump, and I am speaking of the arrangement that was formed in the August 2015 meeting at Trump Tower, prior to that, did you ever preview with a candidate positive stories about that candidate or negative stories about that candidate's opponents?
No.
Prior to that August of 2015 meeting, did you ever give a candidate the opportunity to accept, reject, or make changes to your stories before they ran?
No.
Prior to that arrangement with Mr. Trump from August of 2015, did you ever run attack ads against any candidate's adversaries that corresponded to those adversaries' polling numbers?
No.
The conspiracy with Trump was different in motivation and effect than their relationship with any other celebrity or campaign. It was also illegal. The defense repeatedly pointed out that NDAs are not illegal. This is true, but completely misses the point. NDAs are illegal when they are used for illegal purposes. For example, if they constitute a violation of election law. Using NDAs aren't illegal as an argument in this case is like saying contracts are not illegal to defend a contract somebody has with an assassin. So a lawyer could have looked at any of the 3 agreements on its own, and they would have concluded that it was all fine. But if the lawyer had taken into account the reason for the NDAs, they are clearly illegal. To be fair to AMI, the Sajuden deal was originally pretty standard. They paid way more than they usually would have, but the source agreement was pretty similar to previous legitimate AMI contracts. But this was before Cohen demanded and AMI granted some changes. The duration of the source agreement was changed from 3 months to be in perpetuity, and the breach penalty was changed from Sajuden not getting paid to owing AMI a frankly unenforceable $1 million. They also changed the payment from being upon publication to be immediate. This is especially notable since this change was made after Pecker found the story to be untrue. Thus, they would never publish it, and there was literally no benefit whatsoever for AMI to sign the agreement. But they did sign this deal, which had mutated into becoming very different from their normal contracts. Why did they sign it? Not because it benefited AMI, but because it benefited Trump. The defense also brought up Pecker saying that if the Sajuden story were true, he would have published it. But it was conveniently left out that he wouldn't have published it until after the election. And that's a key fact, because originally Pecker thought it might be the biggest story since the death of Elvis. However, he was willing to risk getting scooped by another news organization rather than publish it before the election. Once again, that doesn't help AMI. It only helps Trump. The McDougal deal is the same. Pecker said that it was National Enquirer gold, but he didn't publish it since it would have hurt Donald Trump. The defense brought up that it's not a catch and kill, since McDougal didn't want her story told publicly. That's again partly true. She didn't want to tell her story. That's what made the AMI deal so attractive. But McDougal was willing to do it. While the AMI deal was being negotiated, Davidson was simultaneously negotiating a deal with ABC. That deal would involve McDougal going public in exchange for a slot on Dancing with the Stars. Even after the AMI deal closed, Davidson texts Howard that he'll be informing ABC that McDougal has decided not to go forward with their deal, but he is careful to do that without revealing the AMI catch and kill. We also heard Cohen say that AMI made tons of money from McDougal's cover and articles, and that was the reason that Pecker didn't need to be reimbursed. Now, Cohen may believe this, but Pecker said that he decided not to transfer McDougal's rights after talking to a lawyer. What was actually said between Pecker and his lawyer is protected, but after the meeting, he decides to cancel the deal. Pecker also testified that the covers and articles were just window dressing to make the deal more attractive to McDougal, who wanted to restart her career. They were also useful to hide the true purpose of the deal, which was to catch and kill McDougal's story. There is no way that Pecker thought that 2 magazine covers and 25 ghostwritten articles by Karen McDougal were worth $150,000. In fact, when Pecker was getting paid back, he only asked for $125,000, since he put the value that AMI got from the window dressing at a maximum of $25,000. Now, we move on to the transfer, and specifically the tape. The defense really wanted to undermine this piece of evidence, and that's for good reason. It completely destroys any argument that Trump wasn't heavily involved in the conspiracy. It may be slightly unclear, but seriously listen to it and see if you can hear the words in the transcript.
I need to open up a company for the transfer of all of that info regarding our friend David, so that I'm going to do that right away. I've actually come up and I've spoken to Alan Weisselberg about how to set the whole thing up with
So what are we going to pay?
funding. Yes, and it's all the stuff. All the stuff, because you never know where that company, you never know where he's going to be. Correct. So I'm all over that, and I spoke to Alan about it when it comes time for the financing, which will be.
Listen, what financing?
We'll have to pay you. So
I'll pay with cash.
No. I got no.
Hey, Don, how are you?
That's proof beyond a reasonable doubt. The defense can nitpick about the prosecution not asking Rona Graf any questions about it. But that's because, while Graf was on the tape earlier, she can be heard leaving the room before the relevant parts that I've played 3 times now. The defense can also fuss about the "Hey Don, how are ya?" But how is that at all relevant? So maybe Cohen thought he picked up a call and accidentally said "Hi Don" since he was just talking to Donald Trump. How does this in any way disprove what's on the tape? The voices sound like Cohen and Trump. Cohen says it's their voices, and the metadata shows it was recorded on the day Cohen says it was recorded. It's also worth noting that the tape was extracted from Cohen's phone, which was seized in an FBI raid from before Cohen was indicted for his charges. The recording was extracted from the phone before Cohen flipped on Trump. There is no way of getting around that recording. It definitively proves Trump's knowledge of and involvement in the conspiracy. Finally, we have the Daniels deal. And it is indeed true that Pecker refused to fund this deal. But that's actually pretty reasonable. Pecker was afraid that associating the National Enquirer with an adult performer would lead to them getting dropped by Walmart. Furthermore, look at how the previous deal went. Pecker paid a huge sum and after speaking to his lawyer decided not to get paid back. It really shouldn't be a surprise that Pecker didn't want to repeat this. The defense also brought up the story in the dirty.com. And while it is true that it was briefly available, Davidson and Cohen worked together to have it taken down shortly after it was published in 2011. This was actually the interaction that caused Davidson not to want to work with Cohen again in the future. The details of the dirty.com story obviously were not public knowledge, and there was a legitimate benefit to Trump's campaign to cover up Daniels' story. Now we get to the point of showing Trump's involvement. Previously, we saw other members of the conspiracy say that he was involved, but now we have the calls and the texts, and we can see that he is involved. On the 16th of June, after Howard gives Cohen the date of his meeting with McDougal, Cohen texts Schiller trying to locate Trump, and they then have a call. On October 8th, Trump calls Cohen about taking down the Radar Online story, which is about the Access Hollywood tape. When Davidson approaches Howard to sell the Daniels story later that day, Howard calls Pecker, then Pecker calls Cohen, and 3 minutes later, Cohen has a 7-minute call with Trump. On October 17th, the day of the first Daniels payment deadline, Davidson calls Cohen, and then Cohen calls Trump. And finally, on the 26th, in the morning, Cohen has 2 calls with Trump before strolling across the road from Trump Tower into First Republic Bank, and he then funds the account to pay Daniels. By the way, these are only the calls that occurred on the key days of the scheme, and also these are just the phone calls. We don't have any records from the signal communications. Then, we also have the fact that Cohen needed Trump's approval when spending any money, like, for example, a $130,000 hush money payment. And finally, we have Cohen's recording. Trump was part of the conspiracy. It has been proven beyond a reasonable doubt. The defense also argued that the stories were bought to protect Trump's family and brand. That's not true. Trump killed those stories to help himself in the election. Let's just look at what the other conspirators articulated. Cohen said that Trump purchased the stories to help his campaign, and Pecker claimed that during the campaign time, Trump never expressed that he was concerned about what his family would think about the affairs that they were catching and killing. We also have these text messages from Davidson and Howard after Trump won the election. Davidson says, "What have we done?" That certainly seems to indicate that they thought their contributions to the catch and kill scheme helped Trump's electoral prospects. We also have Hope Hicks. She's a Trump ally. Here is her testimony.
After it was published and on November 5th, did you discuss the article with Mr. Trump?
I did.
What, if anything, did you discuss?
He was concerned about the story. He was concerned how it would be viewed by his wife. And he wanted me to make sure that the newspapers weren't delivered to their residence that morning.
Did he also ask you whether you thought it was likely to affect the campaign?
Everything we talked about in the context of, this time period was about whether or not there was an impact on the campaign. So certainly I don't recall specifically him saying that. But everything was something that Mr. Trump said a lot is, how is it playing? He wanted to know how things were playing, whether they were playing well or playing poorly. And that could have been a speech, an article, a tweet. So I don't want to speculate, but I'm almost certain he would have asked me, how's it playing? And wanted to know how I felt the next few days were going to go, and if this was going to be a big piece of the next few days.
So even Hope Hicks admitted that Trump was at least in part concerned about the impact of the stories on the campaign. But we don't just need to rely on what Trump told other people. We can also analyze his actions. It shouldn't be a surprise that Trump had relations with Daniels in 2006, but he didn't pay her off until 2016. He didn't care if the affair came out until it would harm his campaign. We can look at Gina Rodriguez's 2 previous attempts to sell Daniels' story. It wouldn't have been a big deal for the campaign, so Rodriguez was just ignored. Then, the Access Hollywood tape was released, and within 50 minutes, she was offered $100,000. It wasn't until Trump was afraid of losing female voters that he silenced Daniels. The Access Hollywood tape wasn't a massive deal for Melania. She literally came up with the idea of characterizing it as locker room talk, but the tape was a massive deal for the campaign. That's the reason they immediately spot Daniels' story. But there's more. How about the fact that Trump instructed Cohen to push the Stormy Daniels payoff out until after the election? Trump would then have not paid and not cared, since it was after the election. That is as definitive proof as we could possibly get that Trump's concern was the election. There is no way that one can say that Trump bought the Daniels story to protect his family or brand if he was willing to buy it before the election, but not willing to purchase it after the election. There is one difference between those 2 days, and it's whether the story would affect his campaign. Just stepping back and looking at the facts holistically, $310,000 was spent by AMI and Cohen to catch and kill stories. But the whole scheme is worth so much more. With the billions of dollars which are spent on presidential races, what would the going rate be for a magazine who is willing to conspire with a campaign? A magazine whose headlines are in the eyesight of every American in every checkout line. A magazine which works with the campaign on positive stories, they work with the campaign on negative stories, and they are the eyes and ears of the campaign, swiping up and silencing negative stories. They are willing to use their sources to negotiate deals for the campaign. It is obvious that it is a campaign contribution and a conspiracy. Illegal means were used to carry it out, and illegal means were used to cover it up. Trump was approving and directing it all, and he did so with the intent of influencing the election. Looking at all the vast amounts of evidence, Wall 4 is clearly and obviously proven beyond a reasonable doubt. This should also make Trump's involvement in the scheme to repay Cohen more probable. Now, by no means does it alone prove it. Just because Trump conspired to influence an election as part of his scheme, which involved creating false business documents, doesn't mean that he also conspired to repay one of those co-conspirators and hid the payments by creating false business records. But it does make it more likely, and we have lots of evidence of Trump's involvement in the repayment scheme, which will upgrade his involvement from likely to proven. To start, it was disputed if Trump ever saw the invoices. Well, he did. He may not have seen the email chains because he didn't use email. Trump knew too many people who had gone down due to prosecutors using their emails in court, but the invoices were stapled to the checks he signed. Tarasov may not have exactly said that she had a specific recollection of stapling every invoice to every check, but she articulated multiple times that for the specific checks in question, the invoices were stapled to them. But we don't actually have to take her word for it, because the invoices are in evidence. The quality is not great, but we can see the staple marks. That is proof beyond a reasonable doubt that Trump saw those invoices and still signed the checks, because he knew about and authorized Cohen being paid back. As for the vouchers, Trump may not have seen them, but the prosecution does not need to prove that. They just need to show that Trump approved the repayment scheme, a scheme which he knew would result in creating false business documents. We already explored Cohen saying that Trump was involved, but another key connection is Alan Weisselberg. He and Trump worked together very closely. Both Rebecca Minocchio and Deborah Tarasov testified that they worked closely together even in the December and January when the repayment scheme was created. Trump also wrote in his books that he works well with Weisselberg. Alan Weisselberg, my CFO, comes in for a meeting. He's been with me for 30 years and keeps a handle on everything, which is not an easy job. He runs things beautifully. His team is tight and fast, and so are our meetings. He also writes about how they worked together in the 90s during difficult financial times, and calls him a loyal employee. Nobody disputes that Weisselberg created the repayment scheme. We literally have his handwriting on the documents laying out the plan. Weisselberg got Trump's approval for this. He had to. He was the chief financial officer who could plan out payments, but he needed Trump's approval. Weisselberg could independently only approve payments up to $10,000. That's less than the $420,000 they paid Cohen, and also less than the $35,000 monthly checks. So Weisselberg created the repayment scheme with Cohen, and they went into Trump's office where Trump approved it and insisted it to be split into 12 monthly checks. Cohen even said that he felt like Weisselberg and Trump had discussed the plan before the meeting. Another key piece of evidence proving Trump's approval are the checks themselves. It is true that he didn't sign the first two checks, but he did discuss the repayment scheme with Cohen during a meeting in the White House around the time the first two checks were issued. We do have physical proof that that meeting happened, by the way. But the strongest checks are those that Trump signed himself. He was in the White House, he saw the invoices stapled to the checks, and he signed the checks. He didn't have to sign them. He refused to sign other checks. He could have called the Trump organization if he had any questions. He did that for other checks. But for the 9 Cohen checks, he saw them and just signed them. Why? Because he knew what they were for. He approved the scheme when it was created in January 2017, and he approved the scheme from April to December 2017 by signing a check each month. The defense brought up that maybe Trump wasn't paying attention when he signed the checks. He was a very busy man, but that doesn't pass the smell test. Are we meant to believe that Trump would be going through his monthly checks and he signs an $80 Verizon bill, a $50 water bill, and then comes to a $35,000 charge from his personal lawyer who is doing basically no work, and Trump doesn't notice that this payment is not like the others? And this has to happen 9 times, by the way. Trump needs a perfect 9-0 record of not noticing something is wrong with these checks. If Trump had called the Trump organization about one of these checks, or if he had refused to sign a check, then maybe there would be an argument that Trump didn't know about the scheme. But that didn't happen. Trump knowingly signed these 9 checks because he knew about and approved the repayment scheme. Also, if Trump was too busy to sign the checks, he could have changed the procedure at the Trump organization to have somebody else do it. But Trump didn't do that. Because he was a micromanager and he's tight with money, so he wants to keep an overview of his finances even while being president. As Trump wrote in his book, "As I said before, I always sign my checks, so I know where my money is going. In the same spirit, I also always try to read my bills to make sure I'm not being overcharged." He also wrote about the importance of keeping on top of his finances in his other books too. Is this the kind of person who mindlessly signs 9 checks for $35,000 each? Trump approved the repayment scheme. He knew that hiding the payments would create false business records, and he approved it. From our timeline, we can also see that what the defense said about Stormy Daniels was untrue. The defense claimed that Daniels was attempting to extort Trump by making up a story and then approaching him and making him pay for an NDA with her. This is completely destroyed by the text logs. Daniels never approached Trump. Her agent, Gina Rodriguez, approached Dylan Howard at AMI. Rodriguez also did this long before she knew Howard was working with Trump. There was no extortion scheme. The defense also picked at small differences between Daniels' previous accounts of what happened in the hotel room and what she testified to on the stand. There were some small differences, but on the whole, it was a very detailed account, and it was almost identical to the story she told previously. But why does it matter if Daniels is telling the truth? Even if her story is true, it doesn't prove any of the aspects that are necessary to find Trump guilty. Well, if Daniels' story is true, then Trump knows it's true, and stopping that from coming out is a pretty strong motivator. We heard her account previously, and it's the kind of information a candidate wouldn't want coming out right before an election. It's the kind of narrative a candidate would be willing to pay and create false business documents to cover up. Which brings us to the intent wall, and once again, information from other walls can feed into this one, but it also includes additional proof of Trump's intent. The first part is the Access Hollywood tape. From analysing the timeline, we have now definitively seen that it was the Access Hollywood tape which motivated Trump's purchase of the Daniels story. This then led to the repayment of Cohen and the 34 false business documents. Now, Madeleine Westerhout did say that the Access Hollywood tape did not rattle Trump, but, well, there's this.
Now, you did not meet Mr. Trump for the first time until after the election, right? That's right. And was that in November of 2016? Yes. And you testified on cross-examination that you really had not spent any time with Mr. Trump until January of 2017, right? Yes, not a significant amount of time. And in the period of November 2016 through January 2017, in that transition period, you testified that you worked out of Trump Tower? Yes. Did you sit on a different floor from Mr. Trump? Yes. And did the RNC leadership in general sit on a different floor from Mr. Trump? Yes. On cross-examination, Ms. Necheles didn't ask you if you had spoken to her before, right? She did not. Have you spoken to Ms. Necheles before? I have. How many times? Once. And when did you last speak to her? 2 nights ago, Wednesday night. On cross-examination, you told Ms. Necheles that Mr. Trump did not freak out about the Access Hollywood tapes, right? Did I? I don't recall saying that. The tape came out in October of 2016, right? Yes. And you did not meet Mr. Trump until after the election in November of 2016, right? That's right. And you didn't spend any real time with him until January 2017, right? Not a significant amount of time, yes. So you have no first-hand knowledge about his reaction to the Access Hollywood tape, right? No first-hand knowledge, no.
Hope Hicks, on the other hand, was actually with Trump when the Access Hollywood tape was released.
Were you with Mr. Trump when that happened?
Yes.
Was Mr. Trump upset?
Yes, he was.
What was your first reaction when you heard the tape?
Just a little stunned. It's hard to describe. Yeah, it was definitely concerning, and I had, a good sense that this was going to be a massive story and sort of dominate the news cycle for the next several days at least.
Were you concerned about the effect it would have on the campaign?
Yes, it was a damaging development.
Why was it a damaging development?
It just didn't feel like the kind of story. It obviously wasn't helpful. But there were a lot of layers to it that complicated where we were trying to go with the campaign. This was kind of pulling us backwards in a way that was going to be hard to overcome.
In those initial conversations with Mr. Trump and other campaign staff, did anyone else the group express concern that the tape would be damaging?
Yes, I think there was consensus among us all that the tape was damaging and this was a crisis.
Were you concerned at the time about the effect that Access Hollywood tape would have on the female voters?
In that moment, no. Maybe a couple of hours later, something that crossed my mind, maybe the next day. But just trying to get your bearings in a moment like that, there is a lot going on. Not in that moment, but certainly eventually that was something that was raised.
You mentioned that you anticipated that there would be an immediate and significant media reaction, right?
Yes.
What was the immediate media response?
It was intense. It dominated coverage for, I would say the 36 hours leading up to the debate. At the time I got the email in the office at 1:30 in the afternoon on Friday, we were anticipating a Category 4 hurricane making landfall somewhere on the East Coast. And I don't think anybody remembers where or when that hurricane made landfall. It was all Trump all the time for the next 36 hours.
The Access Hollywood pushed the hurricane off the news?
Yes.
So, it pushed a Category 4 hurricane out of the news, and it was also the topic of the first question at the following presidential debate. We also know that Trump agreed to buy the Stormy Daniels story the day that the tape was released. He had previously rejected it twice. Trump knew the Access Hollywood tape was bad for him, particularly with female voters. His whole defense against the tape in 2016 was a distinction between words and actions. If a story like Stormy Daniels's came out shortly after the tape, it would have destroyed that defense. Trump needed to stop it from coming out, even if he had to pay huge sums to do it, and even if he had to create false business documents to do it. We also have the fact that Trump was willing to pay Cohen back double just to hide the payment. Given how frugal Trump is, that proves intent. We previously saw how multiple people close to Trump said he was frugal. He also wrote in his books that he is frugal. Actually, here's one more. My parents hammered frugality into me from an early age, and it's the most important money management skill a person can use. Call it penny pinching if you want to. I call it financial smarts. Yet, covering up the Daniels payoff was so important that he was willing to create false business records and pay back double. Trump also valued negotiating, never taking the first offer. You should always feel comfortable bargaining for goods and services. I do it all the time, and I'm one of the richest men on earth. Even in high-end shops, I bargain. After all, the more you're paying for something, the more the seller should be able to shave off the price. I hate paying retail, and it makes me cringe when other people do it. I've walked into stores and offered $2,000 for a $10,000 item. It can be embarrassing for me, especially since everybody knows I'm Trump and I'm wealthy, but you'd be amazed at the discounts you can get if you simply ask. You do have to be willing to walk away, but after you've walked away a few times, the price will come down. Yet, when Cohen and Weisselberg came to him with the repayment plan, he didn't say, $420,000 is a bit much. How about $350,000? He said, sure thing, Mr. Cohen. How about we pay you in monthly installments? Trump put a very high value on covering up the Daniels affair. It bypassed his frugality and it bypassed his honesty. He approved the plan, knowing that false business records would be created, but he was willing to do that to hide what he did. This brings us to our final piece of defense evidence, those being the government ethics form and Trump's tweet. These certainly undermine the idea that Trump was heavily motivated to hide the Daniels affair and payoff. He did tweet publicly about it to his millions of followers, and the ethics form is a public document. So clearly, Trump did not have the intent of creating false business documents to hide the payments if he was also publicly talking about the payments. Except, we have to look at the dates. Trump approved the reimbursement plan in January 2017. He signed the checks from April to December 2017. The tweet was from May 3rd, 2018, and the form was from May 15th, 2018. In January 2018, Daniels went public with the affair. By May, she had done multiple major interviews, and there was no longer any way to cover up her story. Also around May, there was speculation that Trump had used campaign funds to reimburse Cohen. So to counteract this claim, Trump tweets, "Mr. Cohen, an attorney, received a monthly retainer, not from the campaign, having nothing to do with the campaign, from which he entered into, through reimbursement, a private contract between two parties, known as a non-disclosure agreement or NDA. These agreements are very common among celebrities and people of wealth. In this case, it is in full force and effect and will be used in arbitration for damages against Miss Clifford Daniels. The agreement was used to stop the false and extortionist accusations made by her about an affair, despite already having signed a detailed letter admitting that there was no affair. Prior to its violation by Miss Clifford and her attorney, this was a private agreement. Money from the campaign or campaign contributions played no role in this transaction." 12 days later, he signs the Office of Government Ethics form, which includes the payment in a tiny footnote. There's no point lying about it on a form if you've already admitted it on Twitter. And that is how, to deny misusing campaign funds, Trump admitted to a scheme that would result in 34 felonies. He was also nice enough to include language that would destroy his future lawyers' arguments that Cohen was paid for work he was doing or that it was a legitimate retainer. Trump lies and covers up the Daniels affair for as long as he can. He lies and hides until he can't anymore, and he has to come clean. Immediately regretting that, he goes back to lying and in this trial claims that it is a legitimate retainer, claims that he knew nothing about repaying Cohen, and claims that there was no conspiracy to catch and kill the Daniels story in the first place. But those lies mean nothing, because the prosecution have evidence and proved all of those beyond a reasonable doubt. Just like how they also proved this third wall beyond a reasonable doubt. The prosecution brought audio tapes, they brought documents, and they brought witnesses. And it is true that Michael Cohen and Stormy Daniels are witnesses that don't like Trump. However, the other 7 that we have featured do like him. Some of them are longtime friends of Trump, who see him as a mentor. Others have been working for him for over 30 years. Others broke down crying on the stand multiple times. And all of them presented evidence that helps prove Trump's guilt. They had no motive to lie, they swore to tell the truth, and they did tell the truth. There is just so much evidence that proves Trump's guilt, and it puts the defense in a difficult spot. If only Trump didn't have a recorded conversation about the catch and kill conspiracy, or if they hadn't written down the repayment plan, or perhaps if Trump didn't tweet about the reimbursement, then maybe the defense would have a chance. But there is just too much evidence, so the defense needs to pick at the edges of the evidence and misrepresent events, and just hope that the prosecution will mess up and fail to refute them. But that didn't happen. They had an answer for everything. So the jury needs to look at all four walls of this house, and the only conclusion they could possibly reach is that every wall has the strength to support a conviction, and Donald Trump is guilty of every single one of the 34 charges. That's the prosecution's last word, and that's the series. What do you think? Guilty or not guilty? This whole thing is obviously way shorter than the trial, so some stuff needed to be left out. Feel free to leave some of that down in the comments as well. Thanks for watching.